My lord, one matter at 2:30 today, my lord. Today is the public auctioning at 2:30. 3 days back I moved. Today at 2:30, my lord.
It is not listed.
My man.
Have you complied with the office objection?
It is being complied, my lord.
If it is complied, it would have come.
Today at 2:30. Today is the public auctioning at 2:30, my lord. Otherwise, matter become infructuous, my lord. Today at 2:30.
Anyhow, you want, you can take a chance.
Yes, ma'am.
2:30?
Yes.
Yes.
May I make a submission? This is in respect of refund of my EMD for participation, which I have not received. It's only 3 years since the matter is pending here.
We'll see,
And
there is no urgency. Yes.
There is urgency, ma'am.
No.
There is urgency, madam.
No time for the court. Yes.
The matter which I moved yesterday, your lordship had directed them. I don't know why it is not listed.
What happened? Call him. Call, why the memo, if the memo, if they are not coming, why they are not informing? Call him, call the registrar also.
And one more matter, my lord, it's residential property. There's an interim order of the DRT for me to pay the entire amount and take the property back. 3 months they've given time. I've already I'm partially complied with the interim order. This is my only house and I'm put on streets. In the meanwhile, I may put back in possession of that's it.
When was the writ petition filed?
Writ petition filed today, my lords.
It will come. I'll not give any memo for that. It will come. Yes.
Well, it's 2024 rate. I'm the respondent. It's a private financial institution. They have got an adverse order.
Yes.
Maybe listed on Tuesday, my lords. I've moved it few times already.
It will come as per the convenience of the court.
I've already moved. I filed an application to vacate as well, my lords. Maybe listed.
What I'm saying, it will come as per the convenience. Fragment of the vacation, you can't insist for old matters.
I
Yes.
understand.
My lord, loan account is upgraded, my lord.
Huh?
Loan account is upgraded, my lord.
It may be.
Disposed of writ petition, where they had sought for OTS proposal. After I left the court, it seems the advocate of the petitioner mentioned and the 10 lakhs rupees deposit.
No. I said writ petition is not maintainable
Correct.
and dismissed. When the writ petition is not maintainable, whatever the orders, interim orders that are passed, and whatever now, when the court dismisses it saying that it is not maintainable, whatever he has paid, he should be returned back.
No, it seems the further order was made by the.
That's the only thing. Even if today, if I take your memo, I'll pass the same order. How does it matter?
Now 10 lakhs has to be.
It has to be, because when the writ petition is
No,
not.
my lord, the liability of the petition is more than 50.
Let it be. By virtue of a court order, he has paid it. When the writ petition is not maintainable, when the court is not entertaining, whatever he has paid, it should be returned back. That is the order I am passing in all the matters. Not all. In one matter, I've asked the bank to return 10 crores.
I have filed a memo for spoken to my lord kindly. Have it on Monday at least, or Tuesday kindly.
What will happen if I take it out?
No, I would like to submit on how this 10 lakhs will be, if it is going to be this thing that kindly.
Please understand, it's just waste of court's time. Even whatever you submit, it won't make any difference. Because when the writ petition is entertained and granted an interim order, when I'm saying it is not maintainable, they are entitled for that money. It won't make any difference. Unnecessarily, one more matter adding to the list.
The liability is more than 52 lakhs. my lord.
I'm saying I've asked 10 crores to be refunded in a case day before yesterday. So it doesn't matter. Yes, next.
My lords, may I make a mention for a matter on Monday. I'm a senior citizen. My pension and gratuity are blocked on account of disciplinary proceedings against me. If this matter may be had on Monday, my lords.
This is a service matter.
Yes, my lords. I'm a Canara Bank employee.
Huh?
I'm a Canara Bank employee, my lords.
This court is having roster for that.
My lords, this
Don't come under surface of proceedings.
no, it was not under surface proceedings. The matter was between. We figured it was either between Justice Sachin Shankar Magdum's court or this court. It was as a service matter. It was to be listed here.
What's a old matter? Which year is that?
2023, my lords.
Yes. But I'll not take it up this side of the vacation. Yes.
My lord, these are batch subvention scheme EMI matters, my lord. There's an interim order passed in 17/12/2025 directing to stop the payment of EMIs, my lord. Even though banks has been harassing the petitioner to pay the EMIs, and they have even reported it to the CIBIL. So due to which they are not even able to avail any loan, my lord. The same very interim order which has been extended is not reflecting in the online order copy.
Same submission is made the other day also.
Yes, my lord. The matter has not been posted yet, my lord.
It will come. It will come on Saturday or next Saturday.
My lord,
Yes.
my memo may be taken. It may be listed as per your as per this honorable court's convenience.
Take that.
In this case, my lord, number 23, I am withdrawing the petition.
Yes, tomorrow.
My lord.
No, it has been posted today.
Straight.
My-
Then
my
they
lord-
will call.
My lord,
Please wait.
my lord, the memo.
23.
Huh?
My lord, the sale certificate has been issued, my lord, and they're trying to dispose, the bank is trying to dispose me. And the valued property more, my lord, and there are other schedules.
I am not interested to hear the facts first. Which year is the writ petition?
Writ petition, my lord, yeah,
Which
Year,
year?
year.
26. Today, I have filed, my lord.
Writ will come.
My lord,
No, I'll
he's
not.
harassing the petitioner, my
I
lord.
will not grant. You file it today, your office objections are complied, it will come immediately.
At
Yes.
least Tuesday, my lord.
No memo.
Fresh
Yes.
matters, my lord, you are given a liberty to approach DRT. My lord, DRT has dismissed my applications on the limitation aspect, my lord. Not getting into the aspect that I've made already, total amount I've already paid, but they are not getting into that. They are only on the limitation part that.
Don't mention any matter, fresh matter.
Fresh
Fresh
matter.
matters will come.
Fresh
There
matters.
is an SOP, it will come. For that, no memo is required. If you comply with the office objections from mine, as far as my court is concerned, immediately, there is no, every matter has to be
But
listed.
the office will complain, my lord, but still from past 2 days not getting listed. My lord.
Find out. If what your submission is not correct, I will list it after a month.
That's
You want
what,
you want the court officer to verify it? That after the office objections are completed, it is not listing?
that's what my clerk has said.
That's what, please verify and tell the court. If it is not correct, I'll post it after, in the month of July. Yes, call the rest.
Twenty-three, my lord. I'm withdrawing the petition.
Take that.
I'm sorry, my lord. Yesterday I was not came to court, my lord. I could not attend. I'm sorry, my lord. It has become infectious, my lord.
The memo is filed seeking to withdraw the writ petition. Dismissed as withdrawn. Yes.
My lord, see, second list serial number 2, my lord. My lord,
Yes.
actually, I have to go to hospital because for taking physiotherapy, frozen shoulder, I am suffering. So serial number 2 and 12 in second list, may kindly have it tomorrow or any date, my lord, except today. Any date, 2 and 12. I inform the other side. I inform the other side.
List, don't give the date. List after vacation. Yes, next.
Serial number 18, my lord. Girimalaya Press Time. 18, 18, my lord.
Why
Correct.
2013 matter you're asking time? I will not grant.
Liability
Yes.
issue, my lord.
No, I'll not grant. Yes. So unfortunate. 2013 MFAs are coming and advocates are asking time. Yes. Call the list.
My lord, appearing for the respondent
Yes,
bank,
appearing
matter
for-
settled under OTS minutes.
Yes, upon petition. I filed memo for withdrawal, my lord.
Memo is filed seeking to withdraw the petition that the matter is settled between the parties. Accordingly, dismissed as withdrawn.
Obliged.
Okay.
What about this? Yes, CGP.
My lord, this matter, my lord, my instructions are, my lord, the dispute is settled between the parties, my lord. They are misleading the court. And kindly see the representation, my lord. They are making allegation against the circle police inspector. They are alternative remedy, my lord, under section 20D of the Karnataka Police Act. Annexure came, my lord.
No, other day one advocate has argued and how he has distinguished that's not a remedy. What can be decided under 20?
Examined, my lord. 20D, my lord, below the rank of deputy superintendent of police, my lord. They have to give complaint to the as 20D is attracted, my lord. 20C, my lord, above deputy superintendent of police, my lord. In that
And
matter, my
on the
lord,
last occasion, it is the
my
superintendent
lord.
of police.
In that matter, my lord, all superintendent of police, deputy superintendent of police, every police officers are there, my lord. That's why, my lord, they made a submission. In this matter, my lord, they made a allegation against Circle Police Inspector of Parapara Agrara Police Station. 19/6/23 representation.
1 minute. That is the fourth respondent. I think notice is not served on him.
It is, oh my lord, it is not shown. Awaited.
When was it sent? 2023 matter?
Yes, my lord.
R4 notice awaited. When is it sent? List after service of notice.
Interim order.
Yes, next.
Interim order, my lord.
Interim order. What is the interim order in the?
Not to interfere with the possession, my lord.
You are having an interim order. You want action to be taken against circle inspector, not to take, not to interfere with your position from the last 3 years. Interim order earlier granted is extended.
Your Lordship, this is a matter wherein it's an agricultural loan. And for the agricultural loan, the agricultural property was given as security. Collateral was a revenue land. Your Lordship, I had on the last occasion passed on the judgment of the order of this honorable court, wherein we had paid the entire amount. The bank also might have passed this on, Your Lordship. Last time also it passed this on.
Justice Sunil Datta, Justice.
Please, Your Lordship. No, in this, please, that's enough.
That's a copy is there.
Please. So in this matter, this is the only loan taken. And in this loan, it has already been cleared and closed.
Needless to state, the respondent bank is to return the original documents to the petitioner upon completing the procedural formalities for closure of loan.
Please, and
What is impugned in this?
Here, Your Lordship, what has happened is, while that matter was pending, they conveniently went as against the revenue land, which was a collateral, which we were unaware about. The last, when they were asked to file a memo of the calculation, is when we saw that they had sold this property for 93 lakhs.
Certificate is issued.
Sale certificate was issued. They went ahead and completed that also. Now, though we are in possession, the third party interest should not come in. Already the loan has been
Where is the
closed.
third party?
Third party, Your Lordship, notice last time Mr. Shetty did not have a copy, so it was adjourned, Your Lordship. So we served one more copy to him.
So where is his name is not there in the list?
I'm not thinking of that.
No, he is for R1. I'm saying about the auction purchaser.
Please, Your Lordship, Ganesh International. It is respondent number 2, Your Lordship.
That's what happened to the notice to respondent number 2?
Your Lordship.
Returned with postal error.
My lord, respondent number 2,
insufficient-
my lord, Ganesh International is the purchaser. My lord, I'll just clarify what had happened in this matter. My lord, I issued the, my lord, sale notice. One of the property which I sold.
Before going to that, what is this order?
This order, my lord, pursuant to I sold this property which is assailed before this honorable in the present writ petition. I put one more property for auction. That, my lord, sale notice assailed before this honorable court. This honorable court, my lord, they had taken a contention saying that it's an agricultural property. In the meantime, my lord, matter got settled. In fact, my lord, this honorable court directed, my lord, after recovering the money and then paying the money, entire money, my lord, you can, my lord, give some solution to the auction purchaser, and my lord, sale got, my lord, got finality or sale got failed. In respect of the present sale notice which is assailed before this honorable court, page number, my lord, 107, which is, my lord, kindly come to, my lord, that document for a moment, my lord, which I, 106.
Loan is one.
One loan.
If one loan is cleared, there is a question
when
of,
it is cleared, my lord, that is a question. When, my lord, two documents I'll just point out. Well, kindly come to page number 106 for a moment.
Let's take this order dated 27 June 2025.
5. Pursuant to writ petition.
When was the sale in the impugned or sale certificate? When was the sale conducted?
My lord, sale certificate took place on 24/1/2024.
24?
1/2024. The writ petition, that order, my lord, is, my lord, my senior advocate, my lord, handed over. That, my lord, writ petition at page number 79, annexure N. The relief sought before this honorable court at, my lord, page number 90. Issue writ of certiorari, writ of order of direction or certiorari to cast impugned sale notice 14/10/2024. My lord, subsequent to the sale certificate has been issued. In fact, the very same day when the matter came up on board, I filed a memo that is at my lord page number 106.
Your Lordship, based on that memo is when we got to know that they had secretly sold this land. Your Lordship, here the technical contention I have raised is the co-borrowers no more. 4 legal heirs are there. They have not issued notice to the legal heirs.
When was the borrower died?
The borrower died on 29/8/2023. And this auction sale is on 11/1/2024. And 4 legal heirs, they have not been issued a notice. I am not saying repeat 13.2 or 13.4. All I'm saying is your auction, at least if you had let me know, we have anyway cleared the other.
No, even when the original borrower is no more, they have started.
No, it's not so.
He's a co-borrower and he's the main, the husband. He's made his wife as the original borrower. He's the co-borrower. And 4 legal heirs, your Lordship, they have not received. They've given one common address and it has not even been received by them. It was only in this matter when we were closing, when they gave the memo of calculation, did we realize that they have gone ahead and sold some other property given.
Then what is the consequences of this?
This what, my lord,
Please,
I
Your
may
Lordship.
permit to my lord, only 1 minute I'll take. I sold one property. I recovered, my lord, around 91 lakh. I issued a sales certificate. For remaining money, I had to recover huge money. I put other property also auction. That is, my lord, challenge before this honorable court. That is, my lord, writ petition number 31747. That is the order before this honorable court. In that writ petition, I filed a memo stating that one of the property has been already sold. Sales, my lord, kindly see the memo which I filed. It's very clear, and 106 for a moment, my lord, annexure R.
For that, might I state, your Lordship,
Only I'll
page
take 1
70,
second.
just
I'll
1
not
minute.
take more than 30 seconds.
Page 70 will reveal what, if they are claiming that this is what they did, this is for the balance amount. Page 70, then the calculation given is the entire 3.21 crores.
Where do you get that?
At page 70, your Lordship, annexure M. Now, if this is their contention, that would be debunked by the page 70, 14/10/2024. Borrowers, estate of deceased borrowers, 4 people's names.
Yes.
Your Lordship, in this, the amount that they mention is ultimately the entire amount. Now, if they claim that when this matter was closed by this honorable court, entire amount is paid, only a certain portion of interest is
Where do
paid.
you get this amount? I'm not able to find that.
Next year.
In page number 70.
My lord, page number 73.
73, your
Tableau
Lordship.
number
Next
7.
page, your Lordship.
3 crore 21 lakh.
3 crore.
3 crore, my lord, 21 lakh 4,718. Page number 73. Tableau number 7.
This was dated?
This is
10/20/24.
2024. And page 100 also has the same, your Lordship.
And your sales certificate is dated 24/1/2024.
24, much before that. No, my lord, my lord, I'll just clarify. My lord, one property is what? I'll take only 1 minute. One property is, my lord, I put the property for auction around, my lord, approximately 4 crore outstanding. First auction, I am able to sell one property. I, my lord, issued a sales certificate. Subsequently, I put the property for once again auction.
How much amount the property was sold?
91 lakh. 90, my lord, 93 lakh. 93 lakh 58,800. Subsequently, 1 second. Subsequently, my lord, for remaining amount, around, my lord, 4 crores outstanding, 3 crore odd outstanding was there. I put the property for again auction, remaining property. That point of time, the petitioner assailed that particular sale notice, subsequent sale notice. My lord, kindly, my lord, I'll clarify. By that time, when I issued a second sale notice, one property has been already sold. In respect of recovery of other money, when I put the property for auction second time, my lord, writ petition has been filed. In the writ petition, I filed a memo at page number, my lord, 106, stated that one of the property has been already sold. In respect of the property which I sold subsequent sale notice, that is, my lord, my senior advocate took a condition saying that it's an agricultural property, it can't be sold. That time, this honorable court, in fact, they approached the bank and, my lord, the matter got settled between the party, and this honorable court directed some solution has to be given to the auction purchaser. The sale notice which I conducted earlier, that is, my lord, in fact, revealed before this honorable court, they were aware, fully aware. My lord, that's what annexure R, my lord, page number 106, I'm trying to point out before this honorable court.
Just for 1 minute. If
I'll
that
just
was-
point out one document. I'll just point out one document. My lord, 106 annexure R.
Yes.
The advocate for the respondent bank, as per the directions of this honorable court, in order dated 23/1/2025, is hearing producing the copies of the sale notice dated 12/12/2020. That is, my lord, that which sale certificate which is assailed before this honorable court in the present writ petition. and registered sale certificate dated 5/2/2024 with respect to the collateral security which was sold by the respondent bank. The advocate for the respondent bank humbly prays that the same may be taken on record. In fact, my lord, I stated before this honorable court, one of the properties has been sold. The subsequent, my lord, order passed by this honorable court on dated, my lord.
Let's see this order.
Please, my
What
lord.
is the order?
Please,
Based on this 106-page memo is when we got to know that
Page
they
number
had
1.
sold.
Page number 1, my lord, kindly see, my lord, this writ petition is filed under Article 26-27 of the Constitution of India to quash impugnated sale notice at 14/10/2024. By the time my sale certificate has been issued in respect of the, my lord, sale which is assailed before this honorable court. In that sale, my lord, I am able to conduct an auction. That sale, my lord, because they paid the money, my lord, we withdrew the sale. Therefore, my lord, nothing survived for a consideration in respect of the, my lord, sale which already took place.
You're saying they deducted, but not deducted. Your lordship, if that is the case, then that sale notice should contain what amount 93 they sold, they should deduct that and then put the balance up for sale. Then at least we would have known. None of that is done. This memo which they filed in the court is when we got to know that they've gone against our revenue land, whereas this entire loan is an agricultural loan. This was only a collateral, and the fraud played when this matter we paid up the entire amount. They could have said, pay this balance amount which is towards the entire amount, and both those will be released. They don't do that either. They give an undertaking before the court that entire loan is closed, and only one certain portion of the
Let
interest.
DRT conduct all this exercise.
Please, your lordship.
Let DRT look into all this.
Your lordship, all I'm saying is only this much, that if notice goes to this other, the auction purchaser, similar to what happened when we cleared off the agricultural loan, we would have cleared even this had we known, your lordship. All we can't put
the
your
clock
lordship,
back
it is
now.
not on that issue. Might have just gone on a technical aspect that as a legal representative,
That
he
will
is
be
dead.
decided, that will be decided by the DRT by
Your
giving
lordship,
notice to the
that by that time, third party, fourth party interest will come in. He's of course not
Already
in
it must
possession.
have come in. It
Might
is
I
not-
only see?
It is sale certificate was issued on
2 years
24/1/2024, 2
Your
years
lordship,
back.
but nevertheless, he is still not in possession. We are in possession,
Let
and
him continue his
neither has
possession.
he even pursued. All I'm saying is, your lordship, if notice goes out to him, the same way as this honorable court had closed and asked us to even repay that person's money, we will do the same.
Where did the court say that? repay
Your
that
lordship,
person's
here,
money?
your lordship may kindly see.
How can the court grant it?
Your
How can
lordship-
the court say like that? How
Yeah, your
can-
lordship, that
how
is what
can
was
we-
done in this matter, your lordship.
Yes.
One, the date prior to this final order, we were asked to repay that person. And here it is with respect to the interest. Your lordship may kindly see. However, so far as the refund
Yeah.
made to the bidder, the refund may
That
have
is-
to be
that is
made with
contrary to the
interest.
provisions of, we can't, unless and until the court holds that the auction that is conducted is bad and the sale is set aside, nothing all the.
Please, your lordship, all I am requesting is that in view of the fact that his entire sale is bad, in view of the fact that as legal
No,
representatives.
As of now, notice is not served on the
Please,
second respondent.
please, that is
Let
sufficient.
you
Please.
please go before the.
Your
before-
lordship, that might I just request notice to be served on them, your lordship, and that would be the.
Let it be decided. I am not interfering in these kind of matters.
Your lordship,
Please
this is ultimately directly, your
Whatever
lordship,
it is,
legal
not-
representatives.
DRT is
and-
not incompetent to deal with all this.
Your lordship, by the time, your lordship, all I'm stating is, might I request 2 weeks' time, by then we will serve him. and
Waiting
come.
here from the last 1 year, 4 months.
Your lordship, might I seek 1 week's time,
Till
hand
now, notice is not
service.
served. No, if you don't any interim order in this, no interim order.
Your lordship, might I just be permitted to serve by way of hand delivery to the second respondent?
Why should it not be by the DRT? That I'm
Your
not able
lordship-
to- You will get another chance to come before the court.
Your lordship, the lesser said about DRT, the better, your lordship. Your lordship, might I request 1 week's time, I will serve hand summons, your lordship.
It's been pending for one, we'll not.
Your lordship, when I already have an order of this court and I have been defrauded,
To be
your lordship, it
considered all
would
the
be.
more by the DRT, the represented petition is filed, seeking the following prayer. The petition is questioning the sale certificate that is issued in favor of the second respondent on 24/1/2024. The senior counsel appearing for the petition has urged several grounds with regard to that the loan is an agriculture loan and they cannot invoke the surface proceedings, and the sale that is conducted is not in their notice. Already the third party rights have accrued on 24/1/2024 as a sale certificate is issued. This writ petition is filed on 19/3/2025. So far, the notice is not served on the second respondent. The petitioner have an effective alternative remedy before the DRT. But instead of approaching the DRT, the presented petition is filed. And this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. The petitioner shall have the benefit of section 14 of the Limitation Act, where yes, accordingly disposed of, he shall approach the DRT within 30 days from the date of receipt of the copy of the order.
Great.
Yes. Ask her to keep one more copy ready. That is a advocate. Tell him that without even moving proper memos, how do they expect the matters to be listed? Yes. It's memo for withdrawal. It is stated that the memo is filed seeking to withdraw the petition. It is stated that the disputes between the parties are amicably settled. Hence, they want to withdraw the petition. According to the memo, it's not record. Dismissed as withdrawn. Yes.
I'm for the revision petition.
For the respondent, I could not get the wakalat allowed because the records have been sent back long back in September. So I have just informed the corporation. Even I asked him also to send one copy. I don't know whether he sent it. I have to get all the records, my lord. I don't have. In September itself, after the disposal, I have sent everything to the corporation. So I need time, my lord.
How much time?
After vacation, my lord.
This is matter on 8th of June.
Obliged.
Appear for the petition. The matter, my lord, arises under the Karnataka Protection of Interests of Depositors in Financial Establishments Act of 2004. We have challenged, my lord, certain provisions of this act, and I should take your lordships to those provisions, and also 2 notifications that have been issued by the government. Your lordship may kindly turn, my lord, to page 82. That is one notification.
No, I think what about this constitutional validity of
Lords, we are challenging it. I tell you, lordships, why. And I am supported on this aspect by at least 2 judgments of the Honorable Supreme Court.
Yes, it's indeed a surprise. It's indeed a surprise because a statement was made before this honorable court that they're giving up the challenge to the constitutional validity. And this
maybe it was made, but there is a rethinking.
No, it can't be maybe. When a submission is made,
Have been
before the
made,
court, it
but
has to be-
we are withdrawing the submission. We want to challenge it. We want to press our challenge to the validity. We want to press our challenge to the validity of the statute. I'll tell you not just why, my lord. There is a substantial point. Now, my lord, please be kind enough, therefore, to see, my lord, and I tell you not just, my lord, independent of the.
That's the reason why whether the objections are filed with the respondents or on the last occasion, that's how the matter is adjourned because you are not questioning the constitutional validity. Their objections are required to be there on record.
Well, if they want to file it, let them do it.
It's not, it is not that I want to file, my lords. In all
There can't be alternative submissions every time the matter comes. If that's the case, we would have asked them to file their objection. We wouldn't have listed the matter today.
I know.
On the last occasion, we are not pressing on that. That's why we said their counter is not required, so we'll go to the other aspects.
Can I suggest this course of action? In fact, without conceding on the constitutional validity, maybe that question may not arise. Can I place my submissions with respect to two notifications? And if I am right in that, and those notifications go, I am not interested, my lord, in simply challenging the constitutional validity for the sake of challenging.
It was, you appeared on the last occasion or some other advocate?
Somebody. I was not here, my lord. In fact, I was not here because in fact, it's passed over, my lord.
So the submissions keep on changing basing on who the petitioner engages.
I don't know.
If memory serves me right.
That's unfair.
If my memory serves me right, my lords, the learned senior counsel made the submission that they are giving up the challenge to the constitutional validity. The briefing counsel, my lords, will be in a better position to tell.
I didn't make any such submission.
I think you appeared in this matter on the last.
I did, but I didn't make a submission about
Yes,
giving
Mr.
up.
Counsel, wasn't that submission made on the last occasion? Because my court is a YouTube live. We can have it right now. Was the submission made or not is the question.
But we will not go into that question, my lord. I will assume a submission was made.
No, it's
I will assume, my lord.
I want an answer.
Could be, my lord. Let us assume that a submission was made.
I have made a submission that you are not going.
My lord, yes, a submission.
Then I will not consider now. I will not consider that. Apart from that, you please argue.
Very well. I will show to your lordship, my lord, even without going into the constitutional validity.
Yes.
Now, please be kind enough to turn to page 82. What is it that we are challenging?
Now, what is the other prayers that remains?
Well, the notifications issued under the statute.
Notification.
Yes, that is, my lord, there are two notifications which are at page 82 and page 104. Please look at the notification. The one notification, my lord, is dated 29th of June 2021.
Yes.
May I read that for your lordship's consideration? Whereas upon considering the reports of the executive magistrate, that is the deputy commissioner, urban district, and after due investigation of the complaints of depositors, it has come to the notice of the government that Messrs. Vihan Direct Selling
Are you
India
reading at page 82?
My lord, I am at page number 104. There are two notifications, my lord. One, your lordships are right. It is at page 82.
Yes.
The other, my lord, is at page 104.
Yes.
I will take to 82 first, my lord, because that is the first in the sequence under the statute.
Yes.
It has come to the notice of the government. That is 29th of June 2021. Your lordship gets it, my lord, at page 82.
Page
82.
We just now said.
No, 82 and 104. There are two notifications. So please see page 82 first.
Yes.
29th of June 2021. It has come to the notice of the government that the financial establishment, namely so and so, that is the petitioner before your lordship, is involved in fraudulent transactions and failed to return deposits to the depositors. Hence, government has decided to initiate action as per the provisions specified under the Karnataka Protection of Interested Depositors in Financial Establishments Act 2004. The properties belonging to the said financial institutions may have spread over in various districts, and depositors are scattered throughout the state of Karnataka and possibly other states also. In order to avoid duplication of effort, necessity has arisen to authorize competent authority to call for claims from all depositors of Vihan Direct Selling so and so. Therefore, in exercise of the powers conferred by section 5(1) of this act, the government of Karnataka hereby appoint assistant commissioner in respect of so and so with immediate effect as a competent authority. We are challenging this. Next one is at page 104. Please be kind enough to turn to that.
Yes.
One is an order which has been passed under section 5. The other, my lord, is an order which has been passed under section 3.
Yes.
And your lordship may take it, my lord, without fear of contradiction, that both these have been passed without any notice, without any show cause notice, no hearing, nothing. And even while considering, my lord, the constitutional validity of statutes, Supreme Court has said that if you don't give an opportunity of hearing, it is violative of Article 14. And therefore, I am entitled to say that these two notifications are violative of Article 14. Now, my lord, please be kind enough to turn to the second notification at 104.
Yes.
Whereas upon considering the reports of district magistrate, that is Deputy Commissioner, Bengaluru and other, and after due investigation of the complaints of depositors, it has come to the notice that the company are involved in fraudulent Please mark that, my lord, very important. I tell you, Lordships, why. There are now 2 judgments of this honorable court with respect to the same petitioner, where this honorable court, after examining the entire provisions of the various laws in this country, and I'm because the judgment is there before your Lordships, my lord, has come to the conclusion that the activities of the petitioner is not illegal, it's not fraudulent. And now there were certain complaints that had been filed, which is referred to here in these notifications, all of which were subject matter or challenge before the Honorable Supreme Court, and Supreme Court has passed an order staying all further proceedings and all complaints. So, my lord, this is what I wanted to point out, your lordship. And all this was not available to the authority because they just passed an order sitting in the room. If only they had told me, look, it is alleged against you that you are indulging in fraudulent activities. What do you have to say? We propose to take action against you under these provisions of the Act. I would have come and said, no, my activity is not fraudulent. And more importantly, I would have said, I do not come within the definition of financial establishment as defined under this Act. And therefore, you cannot take any action under this Act. No such opportunity was given. Now, my lord, please see the second notification of at page 104, dated 29/6/2021, same day. Whereas, upon considering the reports of District Magistrate as Deputy Commissioner Bengaluru and after due investigation of the complaints of depositors, it has come to the notice of the government that Messrs. So-and-so are involved in fraudulent transactions by clandestinely illegally collecting deposits or money from general public and thereafter have failed to return the same either after maturity or on demand made by the depositors or complainants with promised interest and other assured benefits, and thereby they have failed to render the services promised to them. And I showed to your lordships, my lord, completely wrong statement, because I have never collected any deposits. I don't collect any deposit. There is no question of returning the deposits. I am in business of direct selling. And people, my lord, give money for the purpose of purchasing the project. I supply to them. There is nothing else in this transaction, and this is exactly the ground on which the earlier writ petitions were allowed in my favor. And in fact, recently, my lord, just about 3 months ago, another order has been passed by this honorable court. What happened in that case, my lord, was the postal department said, no, we have received complaints that you are indulging in fraudulent acts. Therefore, we will not accept your goods for delivery on what is called as bulk sales. We challenge that. The High Court allowed the writ petition. I'll come to that. I showed your lordships all these orders. Now, my lord, please see what they say in this order further. And whereas it has further come to the notice of the government that so-and-so company and people associating with them have been acquiring lands, movable, immovable properties, cash and other forms from and out of deposits or money so collected from the depositors or complainants, and thereby deviating from the intended purposes of accepting the deposits or money. Whereas government has reason to believe that the actions of so-and-so and people associating with them are acting in detriment to the interests of the depositors or complainants whose intention was to defraud the innocent depositors, and it has become necessary to protect the interests of depositors of so-and-so. And whereas now the government, after considering the reports of District Magistrate as Deputy Commissioner and satisfying itself about the urgent need to protect the interests of the depositors in excess of the powers conferred by subsection 2 of section 3 of the so-and-so Act, hereby make the following order. Now, therefore, in exercise of the powers conferred by subsection 2 of section 3 of the Karnataka Protection of Interest of Depositors in Financial Establishment Act 2004, the government, under the circumstances stated above, having satisfied that in order to protect the interest of depositors, necessary to attach the movable and immovable properties believed to belong to Messrs. So-and-so. Therefore, the government hereby attaches all movable properties as specified in the annexure to this order, believed to have been acquired by so-and-so, either in its own name or in the name of any other person, from and out of the deposits collected by so-and-so, and where it transpires that such money or such other properties of the said establishment or the personal assets of the promoters, partners, directors, managers or members or any other person of the said finances is not sufficient for repayment of the deposits or interest or such other assured benefits to the depositors. Note, all the aforesaid movable assets on the date of publication of this order in the official gazette shall forthwith vest with the competent authority who has been appointed by the government, pending further orders from the special court. These are the 2 orders that have been challenged. Now, my lord, please look at the provisions of the statute.
Let's look at the definition.
My lord?
Let's look at the definition.
Yes, but your lordship are kind enough. Please be kind enough to look at the definition of section 3(4). In section 3, I'm sorry, section 2, subsection 4. Financial establishment means, your lordship, financial establishment means any person or group of individuals accepting deposit under any scheme or arrangement or in any other manner, but does not include a corporation or a cooperative society owned or controlled by any state government, a central government, etc. Now, my lord, the word deposit is what is used in section 2(4). Now, please be kind enough to turn to section 2(2). Deposit includes and shall be deemed always to have included any receipt of money or acceptance of any valuable commodity by any financial establishment. So first, my lord, it should be a financial establishment, and that financial establishment should accept a deposit as defined in section 2(2) by any financial establishment to be returned after a specified period or otherwise, either in cash or in kind, or in the form of a specified service, with or without any benefit in the form of interest, bonus, profit, or any other form, but does not include. Now, please be kind enough to turn, my lord, to section 2(5), my lord. It does not include amounts received. Which does not include amount received in the ordinary course of business by way of security deposit, dealership deposit, earnest money, advance against order for goods or services. Now, we are saying this was advance against an order for goods and services. Therefore, this is not a deposit. If it is not a deposit, my lord, we are not a financial establishment, and therefore no order could have been passed either under section 3 or under section 5. Now, my lord, therefore we have challenged these two notifications. Under the statute, my lord, there are two ways in which an attachment can be passed. One is by having recourse to section 5. The other is by the competent authority having been appointed approaches the special court for attachment, and the special court passes an order of attachment, and that special court has got the power also to raise an attachment. We are not in the second silo. We are in the first silo, where the government attaches the property in exercise of power under section 3. Now, please see section 3, my lord.
Yes.
The government of the district magistrate or the district magistrates in the respective jurisdiction, suo motu, are based on market intelligence reports or police authority on receipt of. I'm sorry.
Your first contention needs to be answered. Then only, like, if your first contention that is raised is correct, we don't have to go into the other aspects.
I'm sorry, my lord.
Your first contention that you are not a financial institution, it is not a deposit.
Yes.
Once it is answered, then the remaining things you don't have to argue.
Yes,
So
but what happens? But what happens, my lord, is this. Now, as to whether I am a financial institution or what I collect is a deposit, who will determine? The government has to determine under section 3 or under section 5. There is no provision for issuing a notice to me. Therefore, my lord, the courts have held, read into the provision the requirement of notice, hearing. That is how, my lord, constitutional validity of statutes have been upheld by the court by reading into the provision the requirement of natural justice. Therefore, I am entitled to contend before your lordship that the notifications issued under section 3 and under section 5 in the present case have to be struck down because they are issued in violation of the principles of natural justice. Of course, my lord, if your lordship come to the conclusion on the basis of the facts which I am going to give to your lordships that this is neither a deposit nor am I a financial establishment, therefore the question of exercising power either under section 3 or section 5 does not apply. Therefore, there are two courses in my respectful submission, my lord, which is available for this honorable court. One is to set aside these two orders and then say, please consider it. Second is for this honorable court to go into the question as to whether I'm a financial establishment or deposit and And I would say, my lord, strike down the two notifications.
Yes, I will ask.
Very.
My lords, the first submission, my lord, that the opportunity of hearing has not been given, and hence, my lord, both the notifications don't stand the test of law is the first submission.
Forget about the
Please,
natural
my lord.
justice.
Please, my lord.
Now, this as per the act,
Please.
whether he falls under the definition of a
Please,
financial.
I'll submit that they do, my lords.
That's
They-
a,
they
that's a
do,
core
my lords.
issue.
My submission is they do, my lords. Even before I answer, my lords, the contentions, my lords may kindly take page number 243 and 244 of the petition compilation. So whatever may be the nomenclature of, my lords, the business or the module that they follow,
240.
243, my lords, is a statement. It's, my lords, the complaints given by various persons who are affected, my lords. Kindly see, my lords, the last three lines at the foot of the page, unnumbered paragraph. It starts with thereafter, my lords. Please, my lord. I'll read the entire paragraph, my lords. Thereafter, in April 2013, so and so informed my wife that the seminars of the company are arranged on 7/4/2013, college near Holy Family Hospital, so and so. My wife attended both the seminars, and the instructions of Mr. so and so, and endured my wife to invest money into the scheme on the pretext of, my lords, it's not very clear, the copy that's been served on me, my lords. Returns on it, and income could be earned by introducing new members to the scheme of the company. My lords, I will not say for a minute that this statement is correct, but it has to be put to test. What's the test of a Ponzi scheme, the test of a pyramid scheme? If it is not a simpliciter business transaction of paying money and getting the product and selling it to somebody else, if at all I'm circulating the money from one to another, then, my lords, it will fall under a Ponzi scheme, a pyramid scheme, and then, my lords, it becomes a financial establishment and a deposit. I will establish, my lord, how it is a financial establishment. I will establish how it's a deposit. But before that, my lords, I'm only bringing to your lordship's notice the complaints filed based on which, my lord, section 5(1) and 3(2) have been issued.
Next statement.
My lords,
Where is the other one?
244, my lords, 244, again, the last unnumbered paragraph at the foot of the page, 244, my lord. During access to the internet, I also realized that all the products that were being offered to new members were recruited by the existing independent representatives of the company. I also came to know through my sources that the independent representatives of the company are collecting the joining amount from new members in cash and not accepting checks, pay orders in the name of the company. This raises further suspicion in my mind. Because unnumbered paragraph number 3, my lords may kindly take, my lord. According to the old members, am I able to point out, my lord? According to me, the old members of these above mentioned two companies were shifted into the new company called Vihan Direct Selling India Private Limited, address so and so, Karnataka, as an upline independent representatives to disguise them innocent new members. The old members of the Quest New Enterprises may have been migrated to the new company Vihan so and so to arrange them as upline of the binary tree of the scheme of the company. Therefore, the real beneficiaries will be the original older members of the Gold Quest International Private Limited and Quest India Enterprise Private Limited, and the new downline members will be suffering loss after some period of time as the scheme progresses. Or the last unnumbered paragraph at the foot of the page, my lord. The company so and so, which is operating. My copy is not clear. Permits me, my lord. The company, the website, Commerce Venture, to hide the fact that they are operating in illegal product-based multi-level marketing scheme and cheating innocent under the garb of selling products online for which the price of the product services are not displayed, and no ordinary citizen can purchase any of the product services without entering the details of independent representatives for references. Plus the fourth unnumbered paragraph, according to the whole scheme, there is an endless chain of recruitment and the participants are expected to recruit more and more members to earn money. Participants can earn money only through recruiting more and more members. Participants are expected to have deeper downline to achieve higher positions in the company. Most of the rewards and earnings are distributed to the top members. But this is a classic case of a pyramid, a Ponzi scheme. Now, my lords, I can understand somebody saying, I'll give 100 rupees, buy whatever I'm giving, sell it at whatever MRP you want to. Here is a case, the company makes profit, not only, my lords, from selling, but saying if you make 10 more members, you are going to get this profit. But the criminal cases may not have much of a saying, because what fell for consideration is whether it's a fraud under the provisions of the then extant IPC, not under the provisions of this act. So a deposit, my lord, it may be whatever may be the nomenclature, whatever may be the business transaction, whatever may be the module of the transaction. If at all I am saying that I am going to take some money and give it to you with profit or without profit, and if that money does not come as much from my pocket, as much as I'm circulating the money, I take 100 rupees from my learned friend, and if you have to appoint 10 more people.
Issuing a notification under section 3 of the act
Please,
is not
Lord.
a simple step.
May not,
It's not a simple
Please,
act.
please,
It is by
please.
virtue of that, all the properties of the concern
Please,
is
Lord.
notified.
Please,
So
Lord.
at that stage,
Please,
why not, why, what is the difficulty
Please,
in
Lord.
giving audience to
Please,
the
Lord, please,
person?
Lord. That gets me to this question, my lord. Whether issuance of notice before issuing 5.1 and 3.2 can be read into or is contemplated. Plus, I'll take my lords to the provisions. My lords have gone through the
It is
provision.
not contemplated.
It's not contemplated.
That's the
Point
whole
one.
issue.
I ask myself, why not, my lords? I ask myself, why not? But as far as 5.1 is concerned, a mere appointment of somebody as the competent authority.
Stage of 3.
Please, my lord. 3.2, my lord, 5.1. Since 5.1 is challenged, 3.2, my lords. 3.2 is not an order which determines any right qua the liability. My lords, kindly see. As a the government issues the notification on being satisfied with the reasoning given by suo motu or other officers. It issues a 3.2 notification, and the property stands vested with the government till orders of the Honorable Special Court. But there is a preemption in the act. There is a caution in the act. Once 3.2 is issued, but there the matter doesn't end, my lords. The 3.2 notification, in all humility,
May not be in a final, not a final order, but still, why not? Now, somebody gives you a complaint of this nature,
please, my lord.
but according to the petitioner,
Please,
this is not what he is doing. He is doing something
Please,
else.
ma'am. I'll come to
So
that.
prima facie, not
Please,
you don't have to do a rowing inquiry there, but a minimum, but hearing the other side, what is the difficulty?
Please, my lord. First, the opportunity of hearing, my lords, can be given, should be given, before any rights are crystallized or liabilities are imposed. But I am not a court. The government, when is issuing a notification, the government is not acting as a judicial or a quasi-judicial authority. It is for this reason that the law requires that this attachment be made absolute by the Honorable Special Court, where, my lords, on me filing a 5.2 petition, enough and more opportunity will be given, my lords, to such a person. He can, all that he wants to say before this Honorable Court, or he's saying before this Honorable Court, he can say before the Honorable Special Court. The Honorable Special Court, my lords, will put him on notice, consider the objections, and if at all, my lords, the disputed questions of facts are answered in favor of the petitioner, my lords, there ends the matter. And if
it is not such a as you're putting it, it is not so simple. Though the order at 3.2 is not a final order and subject to so many things.
Please,
but by issuing a notification under 5.2,
please,
you know, it will have an impact on it has its own consequences.
Please, my lord, in similar enactments, my lord, in Land Acquisition Act, my lord, especially in the KDB Act, plus 28.1, my lord's notification is issued, 28.4 notification is issued. The question that very often falls for consideration of the Honorable Court is, when 28.1 notification is issued, but no right of audience or of opportunity is given. But before 28.4 is passed, Lord, the concerned landowners are called upon to file their objections.
Clearly, facts of the case of this nature.
Please, my lord.
According to them, they are doing something. They are only direct selling.
Please.
They're not doing anything else. But the complaints are contrary to their what is the nature of their business.
Please, my lord.
In those circumstances, if you just, it's not going to make any difference. If you just find out what it is, no, people who are competitors in the business or somebody must have given these kind of complaints.
Because it's nobody's case, my lord. It is nobody's case.
No, I'm saying, you know, we are on a general.
Please, on a preposition, I board on, my lord. I board
So
on.
in those circumstances, what is the difficulty?
Please.
Ultimately, you are at liberty to do whatever you want to do.
Please.
If you feel that you are not convinced with what he is saying, you will issue a notification. So what is it the government is losing by hearing the party?
Please, my lord. But in this case, my lord, it's only one company. But there are several cases which come up where 3.2 notifications are issued, where not thousands of properties are attached. Because it's practically impossible for the government to hear all the 1,000 people. But ultimately, my lord.
No, all the people, not all the people. About against whom? No,
please, my lord.
You will attach the properties
please,
of
my lord.
all the people. But the complaint is, against one person.
Please, no, but I cannot say, my lord, only if there's one complainant or one person is going to be affected, I'll hear. And if there are 1,000 properties of one property of each, 1,000 people, I'll not hear. The law cannot make such a discrimination. At the end of the day, my lords, the government will not sit as, my lords, a judicial authority. At the same time, the government is not saying, I'm saying this and the property stands attached. But I ask myself, if I do not have skeletons to hide, why do I close my cupboard? What stops me from going before the Honorable Special Court? Because a very learned, fine judge with a real good understanding of law is made a judge. What I ask myself, what stops me from going and telling the Honorable Special Court? Because, my lords, disputed questions, whether or not, my lords, what the money they are taking, whether or not they recruit more people, whether or not they are, my lords, circulating the money in the cycle, whether or not, my lords, the people at the top of the pyramid are getting more profit than the rest of them. These are all highly disputed questions of fact. But if an opportunity is given before this honorable court, my lords, I'll establish. But whether I want to make this honorable court a fact-finding forum is a different question. So to a pointed question of your lordships, so why would not the government issue a notice or give a right of audience at the point of time of 3-2? That is because, my lord, the law contemplates that once a notification is issued, there will be a judicial order. Kindly see, my lord, at the best, whatever the government passes is only, my lords, an executive fiat or administrative order. This will have to be, my lords, converted into judicial order. So that's how, my lords, the law even says within 30 days. I have to go before the Honorable Special Court and say, government has issued a 3-2 notification based on this information. Please make it absolute. There are several cases, my lord, where the 5-2 petitions have been rejected.
That says the special court will issue notice to everyone.
Please, my lord, I'll point out, my lords. And law provides, even if for some reason no notice is issued by the special court, any person so aggrieved can go and file objections and show cause. So as to why the notification or ad interim attachment should not be made absolute. And the law further provides and contemplates, if no such response is given, then the court shall, my lords, make the ad interim attachment absolute. So the right of audience, not by the executive, but by the judiciary, my lords, has been inbuilt in the act. So nobody can come before this honorable court and say, I have been denied of an opportunity of audience, I'm going to be punished, liability is going to be imposed on me. No, please, my lord. Kindly appreciate this, my lord. The petitioner, if at all he were not to have approached this honorable court, I would have gone before the Honorable Special Court, filed the 5-2 petition. 2021, my lords, the Honorable Special Court could have given a finding based on fact finding either this way or that way. For a minute, my lords, I'll not shirk from my responsibility of producing documents, complaints before this honorable court. But the only difficulty, my lords, I will not convert this honorable court into a fact finding committee. Especially when there is a statutory judicial remedy available to the petitioner. But this is nothing but a straight jacket short circuiting of the procedure given under the law. It's convenient for me to approach this honorable court, not so convenient to go before the special court, so I am here. In which case, my lord, the very purpose and provisions under section 5 clause 2 read with the powers of the special court would become redundant. Every matter, every 3-2 notification, I'll come before your lordships and challenge it. I ask myself, can by a judicial interpretation, can a provision of the law be made odious or redundant? So I ask myself, why only one company, High Court will consider the facts and in all other matters, my lord, persons will go to special court. But either ways we look at it. Perhaps I filed a very brief synopsis, my lord. It is in a form of a bullet forms. And my lord, kindly, I've served a copy on that. File agide, madam. It's on record. It's on record. But both on the technicalities, my lords, and
When
on.
was it filed?
My lords, it is filed, my lords, on 9/4, my lords, 9th of April, my lords. My lords, permit me, my lords, copy has been served on the other side.
It appears to be 17/2/2026.
9/4, my lords, 9/4/2026, my lords. It is dated 9/4/2026, my lord. My lords, may kindly permit me to.
Yes.
But there's one more apprehension, my lords. Why at the stage of 3-2, so much of time is not given. Ma'am, sit up. My lords, may kindly permit me. My lords, kindly, my lords, I will have to bolt, my lords. I'll have to close the doors even before the horses run out. If at the time of section 3.2 notification, I call them and say, I propose to attach your property one day, you please give a response. Because even before that, my lords, all the properties, most of them, lords, would have been sold, or my lords, I will be put in a position where I will not be able to recover anything. The over enthusiasm of giving an opportunity would result in a situation wherein, my lords, I would lose all that I have and the depositors will be left high and dry. Even now, my lords, after filing of the FIR, before the government issues 5.2, my lords, people sell the properties, concerned persons sell the properties. It is for this reason that section 13 is incorporated in the act, which says any mala fide transfer before or after the issuance of the notification or the commencement of the act itself, I can file a petition before the Honorable Court. This is the reason, my lord, and it has an inbuilt mechanism of providing protection to, my lords, the persons concerned. My lords will kindly take, my lords, my note, my lord. I've given, my lords, at page number 6 how it would come within the bracket of the financial establishment. In page number 7, my lords, I would say how I'll not read and waste your lordship's time, my lords. At page number 8, my lords, 10, my lord. 10. It's at the top of the page. Maybe it's small font, but sir, ma'am, at the foot of the, my lord, at the foot of the page, 10, my lords, petition is prematured and even otherwise not maintainable. The petitioner will have full opportunity before the Honorable Special Court to contest the attachment, to establish that properties are not traceable to depositors' funds, and to seek release before the Special Court.
To the points or to the page number?
Because I am referring to page number 8, which is the top of the page, my lord. I am referring to clause 10, my lords. The subhead is, my lord, petition is prematured and even otherwise not maintainable. The petitioner will have full, I'm able to point out, please, my lord, please, my lord. The petitioner will have full opportunity before the Honorable Special Court to contest the attachment, to establish that the properties are not traceable to depositors' funds, and to seek release before the Special Court. The issues raised by the petitioner involve disputed questions of fact, tracing of funds and money trail, examination of schemes and transactions which are unsuitable for adjudication under Article 226. The Special Court under the Act is the exclusive forum to adjudicate the issues. My lords, I'll skip 11, my lords. I'll invite my lords' kind attention to para 6, my lord, at page number 10, at the foot of the page. But admittedly, my lords, is a MLM or a direct selling, whatever the nomenclature, my lords, they choose to call, can also be an illegal pyramid. No, I'm saying also can be. I'm not saying every such scheme is indeed. Based in the context of the complaints that have been raised, it's not possible to say, I am on direct selling, so I will not be called as a pyramid. I will not be called as a Ponzi scheme. No, please, my lord. It cannot be. At para 6, my lord, MLM direct selling can also be an illegal pyramid and or on a Ponzi scheme. It cannot be held that MLM can never be a Ponzi scheme, though every MLM direct selling need not be a Ponzi scheme. Merely labeling a scheme as MLM, direct selling, or network marketing is immaterial. Courts examine the economic reality, not the nomenclature. The substance over label test. So I have pointed out, I'll not waste your lordship's time, my lord. In fact, my lords, at clause 5 at the foot of the page, I refer to a judgment of the Honorable US Court, not with the conviction that it is binding on my lords, but some judicial application of mine, my lords, has indeed gone into. So all these facts, my lord, at para 7, at page number 12, if I have my last way to kindly take, whether the profit promised is recruitment dependent, but the complaint says so, my lords. 2, whether the profit promised is contingent on enrollment, the complaint does say so, my lord. Whether the cash flow is from old paid to new, the complaint does say so, my lord. And the rest of them at page number 13, my lords. So these are highly contested, disputed questions of fact, which a judicial forum most suited, appointed under the Act, will go into, is my very humble submission, my lord. And these facts, my lord, are in the background of the submission that they are not challenging the constitutional validity, even otherwise. Even if one were to challenge the constitutional validity, my lord, on more than 3 occasions, not about KPID Act, but the Act's perimeteria to the provisions of KPID Act, my lord, especially the TNPID Act, the MPID Act, on more than 3 occasions. In the New Moons case, my lord, in Bhaskaran case, the Honorable Supreme Court has upheld. Though, my lord, their lordships say that this is a sort of a draconian act, but nevertheless, their lordships say is required for the times that we are now facing. So, my lords, my very humble submission, my
Where
lords.
are those judgments you have cited in this?
So one, my lords, it's an American judgment, I'll produce it, my lords.
Leave it to the court officer.
I'll leave it to the court officer, please, my lord.
Not, there is a fallacy in the submission and in the reading of the statute by the other side. If your lordship will kindly see, my lord, section 10 of the statute. I'll meet the contention first with respect to the special court. Without, I'll take your lordship the provisions of the act, but before I do that, I may point out to your lordship, there are two ways in which an attachment can be made. One is by the government, not by the competent authority. All that my learned friend is arguing is on behalf of the competent authority. Today, the order that is impugned before your lordship is not by the competent authority. The attachment order has been passed by the government.
After that, what happens?
That's the problem, my lord. That is the problem. Now, once it's attached, now kindly see what happens under the provisions of the statute. Yes. Today, I am on the threshold. Can the government, in exercise of its power under section 3, pass an order of attachment, which can be tested before a special court? There is no provision.
Let's see.
Yes. Your lordship may kindly now see, my lord, special court is under 10. Now, please be kind enough to turn to section 12. Upon receipt of an application under section 5.
Read 10 also.
10 also. I'll read. For the purposes of this act, the government may, with the concurrence of the Chief Justice of the High Court of Karnataka, by notification constitute one or more special court consisting of a single judge not below the rank of a district or sessions judge for such area or areas or such classes of cases. Provided that if the government is of the opinion that where cases pertaining to any financial establishment are spread over more than one district, the government may, with the concurrence of the Chief Justice of the High Court of Karnataka, by notification designate one court of district or sessions judge a special court to deal with all such cases pertaining to such financial establishment. No court, including a court constituted under the present. So may I skip that part? May not be relevant for the purpose. Kindly see 11 now. The special court shall have all the powers of giving effect to the provisions of this act. Without prejudice to generality of subsection 1, special court may have, but several provisions are there which may not have, in my respectful submission, bearing on the point in issue. What is relevant, in fact, my lord, is section 12, because it specifically talks about attachment. Upon receipt of an application under section 5, the special court shall issue to the financial establishment or to any other person, if any, whose property is attached by the designated authority under section 3, a notice accompanied by the copies of the application and affidavits and of the record of evidence, if any, calling upon them to show cause on or before a date to be specified in the notice why the order of attachment should not be made absolute. Now, my lord, your lordship may kindly see, it is upon an application under section 5. Kindly now turn to section 5. Here, my lord, there is no application under section 5.
Yes.
That is because, my lord, your lordship gets that it is an application that has to be made.
No, according to you, after a notification is passed by the government, no ratification is required by the court.
Unless an application is filed by the competent authority under section 5.
Competent authority will
has not filed it.
The competent authority now, in some cases, it would be done first by the government, and in some cases, once a competent authority is appointed, he will take it forward. So it doesn't mean that once this notification is issued, that is final, that the court has no power under 12.
Kindly see section 5, my lord, for a minute.
Yes.
My lord, I am entitled to even question a section 3 notification. Otherwise, my lord, can it be said that I have no remedy at all against a section 3 notification? And the government, my lord, when it issues a notification under section 3, becomes the final authority.
No.
Even if it is.
1 minute. No, either a notification issued under 3 or under 5. Ultimately, whatever is the procedure under 12, it would be the same for the 2.
No, 5.2, my lords. They're saying that there is no method of going to special court. My lords, may kindly take page 5 clause 2, my lord. The clause of section 5 referred to in 12 relates to 5 clause 2, my lord. Clause 2, the competent authority shall, my lords will kindly appreciate the word shall, within 30 days from the date of the receipt of the order made in so and so, section 3, applied to the special court for further order of attachment.
Yes, it is there.
Very much there, my lords.
If my learned finishes, my lord, I'll argue.
No, it's not about finishing. It's all about for the court to understand.
No, my lord, that
so
is
if you ask a
there is
question
a totally
to the advocate, I'll get a clarity. That's why
there is a totally different procedure. My lord, now, here is an order passed by the government assuming that my actions are fraudulent. My lord, that statement itself and all that has been said in the written submissions are not forthcoming in the order passed under section 5. Today, my lord, it is well established legal position that you cannot supply into the order material which is not forthcoming on the face of the order by virtue of a counter affidavit or a submission that is being made in the court. My lord, that your lordships are aware, my lord. Mohinder Singh's guilt says that an order has to be tested on the basis of what is contained there. Now, my lord, if I am able to show to your lordships on the face of it that there are two judgments of this court taking the view that my business is not fraudulent and my business is not illegal.
That you will establish before the special.
No, my lord, then, my lord, what happens is, why should I even suffer for 30 days? The ignominy of a finding recorded in a government order which says my actions are fraudulent. But it is a serious issue, my lord. Even if it is for one day, I will assume. Even if it is for one day, here is a statement that has been made by the government that my actions are fraudulent. I ask myself, before the government formed that conclusion that my actions are fraudulent, should not I be told, look, you're being called a fraud, what do you say? So therefore, my lord, independent of whether they apply under section 5 or whether they don't apply under section 5, the very act of the government itself has civil consequences upon me. Here is a government order that has been passed saying that my actions are fraudulent. Now please look at two judgments of this court, which I want to point out to your lordships, where all this has been, in fact, that was also a case of a complaint that had been filed by a consumer.
When did the High Court say that?
Lord, High Court said it. I'll give your lordship the dates, my lord. Give me a minute.
Meanwhile, if my lords permit me, my lords, the import of section 3, my lords. An application under 5.2 shall be accompanied by one or more affidavits stating the grounds on which the order is made under 3 and the amount of money or any other property believed to have been acquired from out of the deposits and the details, if any, of persons in whose name such person is believed. But if, my lords, I was not to have been interdicted by virtue of the sanctum sanctorum out of this honorable court, I would indeed have knocked the doors of the honorable special court. I would have told them what are the grounds, what are the basis, what is the material that I have. But with these submissions, my lord, I'll rest my submissions, my lord.
Yes.
My lord, if your lordship will kindly see, my lord, page.
Please forward those judgments. Judgments.
Yes, but I'm giving it to you. Page, correct. Page 267. Please be kind enough to turn to the judgment. I will show everything. Kindly see, my lord. Respondent number 2. Your lordship gets it at page 260. I just read a few portions of this order. And there's one, after this, there's one more, which is recent.
Yes.
Respondent number 2 herein is said to have filed a complaint as on 22/6/2016 before the Cybercrime Police Station CID Division, Bangalore, which is said to have been registered as crime number so and so. The second respondent is said to have alleged in her complaint that she is a resident of Bangalore and that a year prior to the complaint, she had come in contact with one Sri Harsha Ramesh, who is said to have introduced himself as a representative of a large international multi-level marketing company known as QNet Limited. That is the petitioner. She is said to have been persuaded by the said Ramesh to join a commission-based network which she could manage from a residence. She was said to have been lured by the promise of large profits by investing nominal amounts of money.
Oh, in this, the petitioner is some individual.
Well, no, petitioner was the director of this company. I showed your lordship.
The petition in this criminal.
Yes. I showed your lordship. She was required to purchase certain lifestyle items through internet transactions, apart from involving 2 others into the business, which could trigger a chain of transactions, and she would receive commission on all sales so generated. The complaint was said to have been told that QNet business in India was being conducted by so and so under one Karthik. She was thus persuaded to transfer a sum of rupees 2.55 lakh by way of online transfer, to a particular account number said to have been provided by the said Ramesh, and it is said to have been handed over a sum of 55,000 in cash. Prior to this, had been called upon to a hotel to meet two women executives of the said company who are said to have attempted to explain the business model to her, and that she had been immediately unsure of the genuineness of the business. However, she was said to have been persuaded to pay the above amounts and also further amounts after raising a bank loan. Complainant is then said to have been invited to a conference where the business was sought to be explained in greater detail. Same thing, my lord, what has been told your lordship just now. But she claimed that she was even more doubtful of the soundness of the business and is said to have demanded a refund of all her money. But she is again said to have been persuaded to attend a very grand conference at Dubai, which was said to have been attended by over 10,000 people, with many celebrities gracing the occasion. After returning from Dubai, it transfers that no one from QNet contacted her. She is then said to have learned from an internet search that QNet was part of another group known as Q1, and that the aforesaid Vihan Direct Selling India Private Limited was being controlled by Q1, which was said to be located in Hong Kong. And the complainant stated that she had discovered that QNet Group had earlier conducted the business in India in the name of Gold Quest International Private Limited and Questnet Enterprises Limited, and that serious legal action is said to have been initiated by the Indian government on account of the shady business practices having come to light. It was further stated that the Bangalore operations of the business were being controlled by one Suresh Timri and Srinivas Vanka, who were said to be actively defrauding people.
Come to the relevant paragraph.
Yes. Now, I read this only to show that the allegations which were read by my learned friend are similar here, only for that purpose.
You can come to page number 286.
Yes, my lord, I will.
Material of
Yes, my lord, I will.
What is this observation? Material of unimpeccable character pertaining to the activities have been produced before the court in a quash petition.
Well, can I trouble your lordship to kindly see para 4 if your lordships are kind enough for a minute? Page 283.
Yes.
On a consideration of the material produced and the rival contentions, it is seen that it is neither the case of the de facto complainant nor the police that the petitioner had committed any overt act in inducing the complainant from parting with any money, or that he had influenced her in doing so, but the petitioner appears to be included in the charge sheet only on account of the fact that he is said to be a managing consultant of QNet. It is not indicated that QNet has a presence in India other than through Vihan. It is not shown that the petitioner is associated with the latter. This circumstance alone would render the proceedings initiated against the petitioner bad in law. He is shown to be a resident of Malaysia in charge sheet. That is yet another. Secondly, the complainant is only as regards the complainant being disillusioned about business and not having received any benefit for money she may have parted with. This could be at best be a civil dispute, or at the worst a cause of cheating by persons or persons who have received the same. It is nobody's case that the petitioner received the money. Then, my lord, kindly see at the bottom of page 284.
Yes.
As contended by counsel for the petitioner and as seen from the abundant material produced here before this court, it is evident that direct selling has emerged as a global industry. A report prepared by the Federation of Indian Chambers of Commerce and Industry discloses that direct selling and multi-level marketing in India is estimated to be to the tune of several hundreds of crores of rupees, and that it has emerged as an independent industry. It is also expressed therein that direct selling and multi-level marketing are forms of economic activity that could play a very important role in a country like India, as it envisages low transactional cost mechanisms for sale of consumer products without the need for large marketing infrastructure. In consideration of the fact that direct selling and multi-level marketing are important industry verticals, the Government of India has issued an advisory to the state governments and union territories, which contain model framework for guideline on direct selling. The model guidelines clearly indicate that multi-layered network of subscribers to a scheme formed by a direct selling company, which consists of subscribers enrolling one or more further subscribers in order to receive any benefit directly or indirectly, where the benefit is as a result of sale of goods or services for such subscribers is not illegal. Materials of unimpeachable character pertaining to the activities of QNet have been produced before this court. Therefore, my lord, the court accepts that our activity is unimpeachable. Now, where do I produce this material?
Even in a quash petition also, you can't produce all this. Even in a quash petition also, you can't produce all this.
It has been produced.
That is what it is.
But in any event, this has now.
No, I'm saying.
This is now become
I I'm not saying anything on that. When you're submitting that, where would I produce? Even in a quash petition also, you can't produce. Because in a quash petition, court can only look at what are the allegations.
There
what
is
the
some,
charge
there is
sheet
some change in that legal position, my lord. Because the Supreme Court itself has held that even though it is true that we started from the position that in a quash petition, you only look at the amendments made in the complaint. Then, my lord, the Supreme Court relaxed that rule a little bit and said, no, if there is unimpeachable material, it can also be looked at. For example, my lord, in that case, what happened was the person.
I think that position was not so. When this order is
In
passed
any event, my lord, possibly the
you
court
will not go into that, and that's not necessary.
No, my lord,
Whatever
now,
it is, let us take it that you're.
No, my lord, I want to read a few portions of this order, if your lordship
Yes.
permit me, because much was said against my client.
Yes.
Material of unimpeachable character pertaining to the activities of QNet have been produced before this court. A perusal of the material in the charge sheet amendments prima facie indicate that the activities of QNet and Vihan, that is multi-level marketing, do not constitute offences under the Price Cheats Act. The activities of
That
the
is a precise, whether an offence that is registered under the provisions of the Act will attract it or not was the issue before the court.
There are a few more findings.
Yes.
I'll read that one, if your lordship permit me. Material of unimpeachable character pertaining to the activities of QNet have been produced before this court. A perusal of the material in the charge sheet amendments prima facie indicate that the activities of QNet and Vihan, that is multi-level marketing companies, do not constitute offences under the Price Cheats Act 1978. The activities of the company do not fall within the definition of money circulation scheme under Section 2C of the Act, nor does it fall within the definition of price cheat under Section 2E of the Act. When the activities of these companies do not constitute either money circulation scheme or price cheat, the offences under 4 and 5 of the Act do not even remotely apply to such activities, and consequently charging the accused for such offences is unsuitable. The report of the FICCI also specify that the absence of clear legislation and regulatory framework for multi-level marketing companies have led to severe problems for such companies operating in the country. The present case clearly demonstrates the fact. Legislation such as Price Cheat Act, which do not even remotely apply to the activities of multi-level marketing companies, are applied by the investigating authorities, leading to disastrous results. Further, prima facie perusal of the FIR and the charge sheet reveals that the ingredients of the offences under 417, 419 and 420 are not made out. Because, my lord, the reason why I'm reading this for your lordship consideration is the order says it's a fraud.
Yes.
Therefore, my lord, I'm pointing it out.
Yes.
The allegation pertains to payment of certain monies in anticipation of
We will
certain
accept that.
services.
We will accept that.
Yes.
Because instead of, we need not go into this so elaborately.
Yes.
That we will take it that there is a quash petition filed and there was a clean sheet to the director.
That's right.
Yes.
Now, if that is so,
Yes.
is this not a material fact which the government should have considered while exercising a statutory power under Section 3 of the Act? Is the question, that I place for your lordship's consideration. And it cannot be said that an order of attachment has civil consequences. Now, it is true that the Act does not provide in specific terms a right of hearing. But, my lord, the Honorable Supreme Court has taken the view that even where the Act does not provide for a specific hearing to be given, the courts, in order to save that provision from being struck down as being arbitrary under Article 14, will read into the provision the requirement to give a hearing. That is a judgment, which I want to point out, your lordships. This is the, which is the judgment on, where is where is that judgment on slum clearance? This one? Yes, Lord, please be kind enough to see the judgment of the Honorable Supreme Court. With respect to, my lord, this Slum Clearance Act. What happened in that case was that under the Karnataka Slum Clearance Act, an area can be declared as a slum area and action can be taken for clearance of that. Now the question was whether that provision is right or wrong.
Paragraph.
Now, if your lordship will be kind enough to turn to paragraph number 2. Can I just read a few lines in para 1 so your lordship knows the contextual provision?
Yes.
These 5 appeals arising out of 5 writ petitions filed with the High Court of Mysore, questioning 3 notifications issued under the Mysore Slum Areas Improvement and Clearance Act 1958. The notifications were so and so. The provisions of 3, 9 and 12 were also impugned as unconstitutional. The High Court struck down 3 and 9 as violating 19(1)(f) of the Constitution and 12(1)(b) as violating Article 14. It did not consider it necessary to consider the constitutional validity of Section 15. It, however, held that the 3 notifications above referred to were not unconstitutional because, in exercising their functions of the 3, 9, 12, the authorities concerned were not exercising a quasi-judicial power. But the result of striking down the sections of the Act above referred to was that the notifications also fell along with them. The state of Mysore has filed these appeals and certificate. There are 2 possible approaches to this question. One is to hold that the provisions of the statute are themselves unconstitutional because they do not provide a reasonable opportunity for the affected parties to be heard. The other is to hold that as there is nothing in the statutory provisions which debar the application of the principles of natural justice, while the authority is exercising the statutory powers under the Act, and as the principles of natural justice would apply unless the statutory provisions point to the contrary, the statutory provisions themselves are not unconstitutional, though the notifications issued under them may be struck down if the authorities concerned do not observe the principles of natural justice while exercising their statutory powers. As there is a presumption of constitutionality of statutes unless contrary is established in its latter course, it is the latter course that appears to be the proper approach. This is this submission I am making, your lordships.
Yes.
There is nothing in the statute which says don't give a hearing. And now, my lord, if your lordship will kindly see how the law has been developed. After having said this in para number 2, please see how the, if necessary, my lord, what I'll do is, I'll put all this in a note.
Yes.
And give it to your lordships, my lord, so that I don't detain your lordships. I know it's early in the morning and there are so many matters. I understand.
Yes.
So, but the entire law, my lord, has been discussed in para number 4.
Yes.
Completely.
Yes.
And then, my lord, at the end of it, kindly see what they do. If your lordship will kindly see para 18. A notification under section 9.
Yes.
A notification under section 9 enables an area to be declared a clearance area on the ground that the most satisfactory method of dealing with the conditions in the area is the demolition of all the buildings in the area. But even in a slum area, there may be buildings which may not have to be pulled down and they may be quite good condition. The proviso to subsection 1 provides for such a contingency. But if there is no provision for hearing the affected persons, he cannot bring to the notice of the concerned authority that his building is not unfit for human habitation or dangerous or injurious to health, and such person would go unheard. There can be no 2 opinions about the need to hear the affected persons before declaring an area to be a slum area. Now, please be kind enough to go back to the notifications which are impugned. Please see how damaging those notifications are. If your lordships will be kind enough to see those notifications, my lord, which your lordships will find at page 182 and 104. Kindly see 104 for a minute. Beyond what is contained in this notification, my lord, nothing can be told before this court. There is not even a reference to the complaint that my learned friend read before your lordships. And I showed your lordship that similar complaints, Supreme Court has stayed all for the proceedings. I'm going to show to your lordship those orders also. Whereas upon considering the reports of the district magistrate.
No, that they have not stated. That submission will take.
That not stated. I don't have a copy of the reports of the district magistrate.
Yes.
I don't have, my lord, the investigation into the complaints that they have made. Nothing. And worse, my lord, is that the company are involved in fraudulent transactions. Well, exactly what was held not to be fraudulent. Because the court was also in the judgment that they placed before your lordship. It is not only the price checks, but also under 420. And the court says nothing wrong about what you're doing. I ask myself, well, if there is nothing wrong in what I'm doing, then where is the question of a finding being recorded in his order that it is fraudulent? This is seriously affecting.
What is the Supreme Court judgment?
Yes, my lord. Supreme Court judgment has been produced. My lord, as part of the compilation. Yeah, the page entry. Supreme Court order entry. Stay order.
263, sir.
Stay order here.
That's a 260. Huh? There are Supreme Court judgments.
Yes, my lord. Yes, I'll give it. Yeah,
263, sir.
Kindly turn to page 263.
Yes.
And I showed your lordship the recent judgment of this honorable court following all this. And it has been extracted. So that may be give your lordship the entire thing. Holy.
You can give all the judgments and refer to it instead of picking the judgments whenever whenever it is asked, so that it will save the court's time. Yes.
Lord, there are, the prayers are all extracted.
Yes.
Kindly see para 6. It is submitted on behalf of the petitioners that they are also agreed by Annexure F, which is a communication with the senior superintendent of RMS to the Registrar of Companies regarding certain information that is sought by the department. Then, my lord, your lordship may kindly see para 8. The petitioners have agreed with the communications referred to above, which they have sought for setting aside at annexes MP and Q. It is the case made out by the petitioners that the impugned orders communication with Postal Department that is sought to be set aside is on a mistaken notion of criminal activities which the department apprehends the petitioner is involved in, and making of such insinuations it is submitted would lead to denial of services as per the orders impugned herein, as a respondent, which is an entity which comes within the definition of state, cannot resort to. Then, my lord, all the contentions are noticed. Your lordships may now kindly see para 13.
Yes.
It is not in dispute that there are certain cases pending before the apex court, in which there is an order of stay by the apex court as regards the pending FIRs. In terms of the orders passed in criminal number so and so, dated so and so, that's what I was about to show to your lordships. It is further submitted that the coordinate bench in criminal petition number so and so and so and so has set aside the action initiated against the petitioners, in which there is a finding recorded that there is no criminality attached to the activities of the petitioner. Though learned counsel Mr. So-and-so submitted the matter is still pending before the apex court as regards certain FIRs, all that could be stated is an emphatic finding regarding involvement of the petitioner in an alleged offence is a stand that is not open to be taken at this stage. Though learned counsel so-and-so appearing for the government submitted certain proceedings are pending before special court as regard proceedings under section 447 of the Companies Act 2013, however, it could be said that at this point of time, such proceedings not having attained finality, any stand taken by the respondent to the effect that the petitioners are involved in criminal, fraudulent, illegal activities is not open to be taken at this stage. Well, it is not to be taken at the stage of when the postal people refuse my parcels. The scheme of the Postal Act makes it clear that Postal Department is a public utility and it offers services which can be availed by all without discrimination. Even in the absence of agreement, renewal of which has been put on hold, the petitioner could avail of the services of the Postal Department except when prohibited. As regards the aspect as to whether the activities of the petitioner are prohibited, there is neither a concluded inquiry nor a conclusive finding by any court as on date which has reached finality. Further, even if such an order is to be passed prohibiting the petitioner from availing services in terms of the Act, no such decision can be taken which could have adverse consequences on the petitioner in the light of the adverse consequences of the petitioner without hearing the petitioner. In the light of the discussion made above, it is not open for the authority at this stage and as on date to take a stand regarding involvement of the petitioner either in criminal activities or fraudulent activities. Clear finding recorded. So, and all that I am saying is before you exercise statutory power under section 5 or under section 3,
yes,
I should be told, look, there is an allegation against. I would have produced all this. I would have told them, sorry, there is no such action on my part. I am indulging in. I would have produced every bit of document to show that this is simple case where people pay money, take their goods, and therefore I am not coming within the purview of either financial institution or a deposit as contemplated under the Act, and therefore the Act itself is not applicable to me.
Yes.
Therefore, my lord, my respectful submission is that if it is necessary to demonstrate as to what is the nature of the activity, my lord, I did not want to take your lordship through all that because I thought, my lord, I would be taking your lordship's time. I can show to your lordships what is the nature of the business on the petition. Who has disputed it? Nobody has disputed it. My lord, somebody wants to be an agent of my client and wants to do business, and maybe they had expectations, maybe they did not have expectations. And if what they got did not meet their expectations, it does not mean that my activity is tainted with criminality. And all kinds of statements are made today before your lordships in the written submission that has been made, where I find one whisper about all this in the order. None of this, therefore, my lord, should be even taken into account is a respectful submission I would make. And we have filed our written submission, Lord. I'll produce all these authorities and answer to their written submissions also, we will file it and your lordship.
Lost permission, Lord. Only two portions of the judgment.
You can give it to the court officer by Wednesday.
Yes.
Only some portions of the order that was read out, my lords, in the order of the Honorable Supreme Court at page number 265. The petitioners are directed to cooperate with the investigation of the case. In the event of necessity of any further conditions depending on the attendant facts and circumstances, it would be open for the concerned trial court to prescribe the same. So, my lords, whatever trial is going on, it could go. And my lords, the order of this honorable court, my lords, all that the Honorable High Court, the coordinate bench said. Only two paragraphs, my lords, kindly bear with me, my lord. The Honorable Supreme Court of India has repeatedly observed that criminal law should not be set in motion to settle civil disputes. This is a civil dispute. I'm going before civil court.
And the law now, my lord, I will file it along with my written submissions. The law is quite clear, my lord. And in fact, Supreme Court has said it in more occasions than one, that where at a particular stage principles of natural justice are violated, it is no answer to say that at a subsequent stage you have the benefit. So in these very words, Supreme Court has said it.
The two judgments also which you are referring.
Bhaskaran, please, bro.
Copies of the
Please, bro. I'll serve a copy on the petition. The last paragraph, kindly bear with me. On the judgment of this honorable court. The instant case is a typical case where criminal legislation which are not even reportedly applicable to the circumstances have been invoked to substantiate the changes. The dispute, if at all, will also kindly appreciate this. The dispute, if at all, is between a consumer and a direct seller and ought to be adjudicated under the provisions of the relevant act. But the honorable court did not say, did not give a blanket order saying that you shall not test the correctness of their business, not the criminal law. But my lord, the same honorable court says it can be under some other law. It's my very humble submission.
Yes, next.
No, page number 10, my lord, of my written submissions, I have noted the same, please. Deeply obliged.
In fact, in one case, my lord,
Wednesday, they'll be giving it.
I may point out, I'll give that along with my written, and I just mention it to your lordships, my lord. Your lordships are aware that under 25O of the Industrial Disputes Act, that's a case of Excel where, my lord, I'll file it along with my written submissions. But I'll just tell you, lordships, what the proposition of law is. These are all neat propositions of law that have been laid down, my lord. Therefore, I cannot resist the temptation of placing it before your lordships. 25O.
They have given already. The petitioner will give.
25O of the Industrial Disputes Act, as your lordships are aware, my lord, provides for closure of an industrial establishment. If the industrial establishment has more than 100, then you need to have take the permission of the government before you close the industrial establishment.
It's larger interest. Larger interest of the people.
Larger interest, yes. Now, my lord, that provision was challenged, saying when the government is looking at whether permission should be granted for closure of an industrial establishment or not, the section does not provide for any hearing, does not provide for any notice, nothing. Supreme Court accepted that contention and struck down 25O. While in the Karnataka Slum Areas Act, they read into the provision the requirement of natural justice, and then said you must hear people before you pass an order declaring a particular area as a slum area. In that case, my lord, Supreme Court struck down the provision. Then, my lord, the law was amended. 25O was amended specifically providing for an opportunity to be given. That was challenged once again. Then, my lord, Supreme Court then rejected the challenge, saying that the defect that we pointed out in our earlier judgment has now been cured because the section provides for an opportunity. Therefore, we upheld the section. And they have elaborately discussed, my lord, what is the requirement of natural justice. And I have showed your lordship two other judgments, which will put all that in a compilation and give it to your lordship.
Will continue.
Lord, this act, only judgment of the Honorable Supreme Court. Lord, cessante rational legis, cessante res ipsa is the principle of law. If the reason for the law ceases, the law itself ceases. My lord, under the Slums Act, kindly see, my lord, section 3, my lord.
My lord, this is, my learned friend says
So
something.
both of you are going on and on.
Only, my lord,
I
my lord, judgment has been read. The judgment has been read. Only section 3.
I will file
Section
it.
3 declares.
That's not relevant. That's
Please,
not relevant.
please, I board on, I board on, my lord, I board on.
Place your,
Please,
yes.
I board on. Yes, obliged.
I appear for
The
responding number
report
4.
says that
My lords, the responding number 4 has taken back entire file. We don't have
the
any
report
instruction.
says
Please.
that never ever it was brought to the notice of the court about the order that is passed within. What is there with you to show that you have placed the order of the court before the learned judge? You must have filed it, if you have to
I'm
file.
taken by surprise with this statement.
But
of the
there's a
learned-
report,
no, 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 no,
elaborate
Of the
report.
report of the learned judge. Second surprised by the report of the learned judge, my lord.
No, the judge says, during my charge of the above said court, neither the learned counsel for the petitioner nor the learned counsel of the respondents have intimated the direction of the Honorable High Court dated 29/7/2024 during directing this court to dispose of the case expeditiously as possible, but not later than 2 months from the date of receipt of the order. I most humbly submit so and so that the order has not been communicated to this court as I have gone through the entire case file. Therefore, I mostly submit that the direction given has not been communicated and even both side counsels have not informed the same. So it could not be complied with in the times prescribed by the High Court. Therefore, I may kindly extend time to comply with the order dated. Copy of the entire order sheet of this case being attached herewith for your kind perusal. So, without even asking the court, without even informing to the court, there is an order of the court. You have come to this court saying
No, I
that
can
the order
only-
is not complied with.
Can only say this.
No, there she has placed the entire order sheet.
This, this must be named by the council. That's also a serious matter, my lord, because it's a helpless woman, my lord, who is seeking for enforce the maintenance of 10,000, my lord, not being paid, and there are specific orders.
No,
And
at
in the
least
usual,
at some point of time, had it been brought to in the entire proceeding sheet after that order is passed, there would have been some mention about it. Now, this order is passed.
would have been communicated.
What is the date of the order?
The order of the order is, my lord, 19th July 2024.
Huh?
19 July
2024.
Oh, sorry,
So we'll
29
see the
July
order sheet
24.
after 19 July. 3/6/2024 is when petition counsel are absent to file memo of calculation as a last chance, call on 6/7. Learned counsel, again it came up on 8/6/7/2024, that is after the order is passed. Learned counsel, the petitioner absent to file memo of calculation as last chance, call on 3/8/2024. Petitioner absent. In spite of providing sufficient opportunities, memo of calculation is not filed. So for last steps, last chance. Petitioner is present, memo of calculation filed, issue notice garnishee to produce such salary certificate if PF paid. Petitioner present. Learned counsel for the petitioner absent, await notice. Office to release the amount to the petitioner. Reissue attachment of salary warrant.
there is a,
This is what is happening.
this is a, I can only say this, there is a saying in this part, Devaru kottaru pujari bida, which means even if the God grants, the priest doesn't allow. We are all advocates are priests. The honorable court has granted some relief to the poorest of the poor. I don't know what is happening, my lord.
That's what it is. That's what she has.
I don't want to comment
The
anything, my
officer
lords,
will
because.
not, the officer will not give a.
No, I may not,
because
I
be
would on,
careful enough to,
No, in
when
fact,
they're,
I should now seek excuse. We do not know because the instruction given by the, this victim is, my lord, that enforcement has not
they
happened, my
will,
lord. Without-
from the receipt of the order, will grant another 2 months time.
He is going to retire on May 31st, nothing will happen
When?
there, May 31st, because the problem is about 10 to 12 lakhs
Then
is
the
there.
court won't be family court will work in a vacation.
This is JMFC, my lords. Magistrate. Civil judge and JMFC works in this. And may I pray, let it be before 15th
The
of.
petition submits that. Then senior counsel appearing for the petition submits that though the order is passed way back on
29 July 24.
29 July 2024, directing the court to dispose of the matter within 2 months. Till now, the matter is not disposed of. This court has called for a report from the concerned court, and the report is placed before the court. As per the report, the judge has taken charge in the year 24. Even before that also, the entire the proceedings are placed before the court, and neither the petitioner nor the respondent has brought to the notice of the court about an order that is passed by this court directing to dispose the matter within 2 months. As such, they could not dispose of the matter. It is stated that if reasonable time is granted, immediately they'll take up the matter. Learned senior counsel submits that the husband is going to retire on May 31st. May 31st, and the matter may be heard.
And this is only execution petition, recovery petition.
Yeah, matter may be heard expeditiously as it is execution proceedings. This order, get it ready by today. Get it ready. The lineage judge shall complete the whole exercise before 30th of May, before 25th of May. The order shall be communicated. The registrar judicial shall communicate this order to the concerned court.
And a compliance report also matched, because the woman, I feel she requires.
This is sufficient.
As my lord.
This is sufficient.
Please, grateful.
Yes.
My lord, I pay for petitioner, my lord. My lord, actually, the auction notice has been called in question, my lord. And earlier, my lord, the similar notice was issued.
Give the earlier writ petition, 8.1. What was challenged?
My lord, there, my lord, auction notice was challenged, my lord, in the earlier writ petition also. And my lord, this honorable court, my lord, was.
You have questioned the possession notice then?
Yes, my lord.
Huh.
And my lord, this honorable
To
court was.
reschedule the loan facility extended to the petitioner. Any interim order in this?
Yes, my lord, there is an interim order subject to payment of 30%, my lord, that has been complied. Now, my lord, again, my lord, they have issued a similar notice.
They will issue. Why will they not issue? Why would you go before the DRT?
Lord,
This protection
Lord,
will be there for another 4 weeks.
My lord, I'll pay another 20%, my
No,
lord.
20%. This is not any, this is the code. The issue has to be decided. There is, if you want to pay the entire amount, we'll give the time, not for 20-30%. And further, you have to question the steps. That is section 13(4). That will be decided. Then it will put a quietus to all this. The writ petition number 23964 of 2023 is filed seeking the following prayer. WP number 12035 of 2026 is filed seeking the following prayer. In the first writ petition, that is WP 23964, the petitioner has questioned the possession notice and a coordinate bench of this court on (30/10/2023) has granted an interim order subject to the petitioner depositing 30% of the due amount. When counsel of the petitioner submits that he has deposited the said amount, and that interim order is extended from time to time. Now, the respondents have issued another auction notification questioning that the petition is before this court. Then counsel submits that he deposits some more amount. When the respondent bank has initiated the proceedings under Surface Act, and the petition is aggrieved by any of the steps that are taken initiated by the bank, his remedy is to go before the DRT. And the earlier writ petition is pending before this court right from the year 2023. Hence, this court is passing the following order. Both the writ petitions are disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. Petitioner shall have the benefit of Section 14 of the Limitation Act. There is an interim order earlier granted shall be in effect, shall continue for another 4 weeks.
30 days time allowed to file the, 30 days time allowed to file.
30 days time to approach the DRT. Yes. Yes, next.
My lord, appearing for the petitioner. My lord, petitioner before this honorable court seeking a writ of certiorari to quash the annexure A and B passed by the second respondent and third respondent.
Who are they?
They are the Deputy Commissioner and Commissioner, Department of Hindu Religious Institution and Religious Endowments, my lord.
What is the order passed?
Declaring that the family temple of the petitioner is a public temple, my lordship. My lordship.
What is why it is wrong?
My lordship, first of all, it is passed under Section 23 of the Hindu Religious and Endowment Act, which is stated by this honorable court, my lordship, at page number 204.
That is different provision. This is also stays there on this provision also.
This provision also
This also comes under the ambit of that one. This also stayed, and the matter is heard by the full bench of the Honorable Supreme Court. There they have reserved. The issue of Section 23 also comes under that. Even to the notified temple and not
Notification is under Section 27.
23.
Notification under Section.
And appointment of trustees under?
It's not under the appointment of trustees.
No, I'm asking appointment of trustees under which provision?
27.
What are the provisions that are stated by the apex court?
That I have to
There
place.
is a relaxation granted to the.
Yes, ma'am.
No, by virtue of that relaxation, they are now appointing. There is an in that stay.
Yes, ma'am.
They've deleted certain.
Certain
Last time
provisions.
I said,
But I have already placed it log.
no. Last time, I think when I was in Dharwad, they placed it before me. With regard to, initially there was complete stay on
Yes,
the
I
order.
agree.
Then after that, some of the provisions were, from that stay, some of them were relaxed.
Yes, ma'am. That is.
Which
that I-
provisions are that?
That I'll place it. I have to go.
Please have that order. See, this is
My lordship, it's been
After
produced
vacation.
at
Look at it, if interim order is there extent.
No, notice, like notice also not.
It's
at
not
order.
even ordered.
Not even order.
Notice on behalf all private party, all.
No, no. 1, 2, 3, my lord.
1,
4
2,
to
3.
7 are the private parties.
1 to
1 to
3, AGA takes notice. 4 to 7, notice to the respondent.
my lordship, stay may be granted.
No,
Yes, my lordship.
no. Yes,
My lords, appearing for the petitioner. My lords, in this petition, we are challenging the rejection of the recall application filed for the taking of a written statement at the DRT, my lords. My lords, in this case, petitioner had availed a loan in 20.
counsel for the applicant present, no representation for the petitioners in I number. Hence petition stands dismissed. Case has been passed over and called upon. Despite that, no representation for the petitioner in the, what is the IA filed?
My lords, we had filed an IA to recall the,
So you file an IA to recall the order, and in that also you will not be present.
no. We filed an IA for recalling of the written statement, my lords, and same was rejected.
IA for?
We, recalling of the order of the DRT dated 19/2/2025. We were placed ex parte as we did not file the written
That is
statement.
what I'm saying.
My lords, we
When
have,
you file an IA, at least when the IA is called, you should be present.
my lords, if I may take you through 2 documents, my lords, we have a very good merits of the case, my lords.
It's
If
not
you-
about merits. We are not on merits. We are
Merits-
only on the point why you are not there. First of all, already a default order is there. You file an IA. On that day also, either in the morning or in the afternoon, you don't be present. What the court is supposed to do? What is the reason? You must have stated something why you are not there in this petition. What did you say?
Due to misentry in the diary, it happened. Due to misentry in the diary, it happened. Misentry in the diary of the advocates, it happened so, my lords. My lords, if I may take you through Annexure B, my lords.
The land counsel for the petition.
My lords, the case is posted for judgment, my lords. I would like to take you through two annexures, my
Land
lords.
counsel for the petitioner submits that on the,
My
they
lords,
filed IA number 1868 of 2025 and 1869 of 2025. And
My
due
lords,
to some communication gap, the
respondent-
counsel was not present on that day and the court had dismissed the IA and the matter is posted for judgment today. It is submitted that the petitioner has merits in the case and without giving an opportunity, now the IA is, now if the IA is not allowed and the petition is not permitted to contest the matter, it would cause lot of hardship to the petitioner. Considering the submission, there shall be stay of all further proceedings in OA number 1946 of 2023 till the next date of hearing. Petitioner shall take out hand summons on the counsel appearing for the respondent before the tribunal and shall file a memo to that effect by 29th of April. List this 27th of April. List this matter on 29th.
Much obliged.
Yeah.
Appear for the petition.
Yes. What is that you're questioning in this?
That we are questioning the action notice as well as
Doing
sought
the
for
auction notice
and also sought for the direction
the
to that we
outstanding
are ready
amount.
to.
under one-time settlement scheme.
He is neither a borrower nor a guarantor, your lords.
No,
Where,
I'm
how
the-
can we
Your
give him
Lordship,
an OTS
that-
offer there?
I'm the person, possession of the property, I'm the owner of the property. Second respondent created the GPA and executed the sale deed in favor of the third respondent. Now both are in abscond. So I file a complaint is no work out.
How can the court pass an order directing the bank to give you a one-time settlement when you are neither a
Because
borrower
as on
nor
date, I'm in possession and all the,
that is, go to civil court, file a suit for injunction, or do whatever you want to do. But the court cannot pass such orders.
because they
The
are
court
concerned,
Don't make,
They are concerned
don't
with the-
continue this illegality.
they are concerned with the,
No.
we are ready
You
to,
have no legal entitlement. The court cannot pass such orders, cannot direct the bank to give you one-time settlement, whatever are the reasons.
If he wants to participate in auction, he can go and participate, your lords.
by-
I'm not coming in the way with that.
The present petition is filed, seeking the following prayer. It is the case of the petitioner that his father succeeded to an extent of 2 acres land in survey number 7 and 6 of Liquid situated at Hotsukerehalli village, Bangalore, under a family partition entered into on 11/1/2001. Consequent to the death of the father, the petitioner and his siblings succeeded to the property. The petitioner constructed 24 residential apartments in the said property, out of which he disposed 23 apartments, retained a 2 BHK apartment measuring 1133 square feet. The petitioner had never executed any sale deed with respect to the property and has only let out the same. When the first respondent forcibly took possession of the apartment, then the petitioner came to know that the second respondent had created a fabricated GPA said to have been executed by the petitioner and his siblings, on the basis of which he had executed a registered sale deed dated 28/1/2010 in favor of the third respondent, and using the said deed, the third respondent availed loan from the first respondent. It is the case of the petitioner that the property belongs to him, which has been fraudulently mortgaged by the second and third respondent. It is submitted that the second and third respondents are absconding. The petition is ready to pay the entire amount in one-time settlement. Hence, there may be a direction to the bank to accept the one-time settlement. Land counsel appearing for the bank submits that petition is neither a borrower nor a guarantor. In those circumstances, the bank cannot accept a one-time settlement, even if the petition is ready to pay the money. Next para, having heard the counsels on either side, there is a material non-report. The fact that it is an admitted fact that the petitioner is neither a borrower nor a guarantor. According to him, he has not sold the property belongs to him. He has not sold the property, and fraudulently certain transactions have taken place. And basing on that, the third respondent has obtained the loan from the respondent bank. All these disputed questions of fact cannot be decided by this court. If the petition is agreed by the sale deed that is executed, he has a remedy. His remedy is elsewhere. Then coming to the aspect of paying the amount and the one-time settlement and direction to the bank is concerned, this court cannot direct the bank to accept the money from the petitioner, who is neither a borrower nor a guarantor. In those circumstances, the petition is not entitled for any relief. Accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy available to him under law in accordance with law. Accordingly disposed. Yes, next.
Petitioners counsel, my lord. Here.
Yes.
My lord, we had, bank had given a letter of credit to us. Court master,
Take that.
please come to my lord.
Who appears to the bank?
Bank, my lord, nobody is here. An irrevocable letter of credit was issued in our favor for 1 crore. And my lord, it specifically says, my lord, that
You have a stay in your favor. Interim order?
no, my lord, there is no interim order.
They're not there.
Very well,
We'll have it
I
after
understand.
vacation. Yes, this is matter after vacation. No representation on behalf of all the respondents.
Please.
Yes.
In serial number 13, I'm appear for the respondent number 4, my lords. My lords, I have to file a statement of objections, my lords. It may be taken up next week, my lords. Petitioner, respondent number 4 is coming.
When did you file your wakalat?
My lords, in the year 2023, I'm apologize, my lords. In the last date of hearing, they have
Once you
said.
filed in 2023, you lost your right to file objections is already elapsed.
My lords, in the last date of hearing, my lords, they have submitted that there is a settlement talking is going on. Because, my lords, since the petitioner and.
No. Finally, list this matter on 17/4/2026. What is the petition about, please?
My lords, it may be pass over, my lords, at least.
Who are the respondents?
Respondent is the husband of the petitioner, my lords. The assistant commissioner invoking his power under section 23.
This is Senior Citizens Act.
Please, my lords.
Between the wife and husband.
Wife and husband, my lords. He cancelled the joint kata made in favor of the husband petitioner and the respondent number 4, my lords. And the deputy commissioner confirmed the same.
No, because wife is 44 years old.
Please, my lord. But he cancelled joint kata purchase under a sale deed.
Husband's age is 65 years, is senior citizen, and wife is 44 years, so an order will be passed under the Senior Citizens Act. We'll give her you have an interim order?
Please.
Yes. Interim order earlier granted is extended until further orders. The list is matter after vacation.
Great.
For filing on the request of learned counsel, the respondent for filing objections. Yes.
Great.
For petitioner, my lord, filing a withdrawal memo.
Take that. The memo is filed seeking to withdraw the petition to say same is dismissed as withdrawn. Yes, next.
Here for appearing for the respondent bank, my lord. Petitioner, last time we have served the copies to our respondent, and we wanted to file. The respondent has been given a bunch of documents, my lord. We want to file the counter affidavit for this, my lord.
My lord, unnecessarily they are taking the. I'll just submit, my lord.
What did I say on the last occasion?
Last date, I have furnished the copy of the affidavit, my lord. They took weeks time to go through the affidavit. My lord, this is a case. My lord, can I make one submission?
In the
This is the
synopsis,
case.
they have filed so many technicalities.
My lord.
We wanted to counter affidavit.
When
My
did you
lord.
file?
This I have filed it on 8/4, my lord.
Where are we now? How many days you require to look into those
Just a
documents?
week, my lord.
He is neither the borrower nor the guarantor, my lord.
Is an agreement holder.
First, you please argue on the merits of your matter. What is your case?
Can I make one submission, my lord? The petition number, the respondent number 2 and 3 had
What is
Senior
the-
counsel will come, my lord.
What is the relief he is seeking?
sale notice, my lord. The Chinese sale notice.
Public auction with respect to the scheduled apartment complex. Issue a writ of mandamus directing respondent number 1 to acknowledge the payment made with the petitioner towards the loan account of the second and third respondent. You have accepted the amount from him?
Yes.
Not from him, my lord. From respondent 2 and 3. The thing is, my lord, 2012, the registered mortgage is there. What they did is, they entered into the joint development agreement with the 2 and 3, construct the building, and 10 flats, they have sold it to XYZ. And they have availed loan from some other banks. We came to know only when the loan account had become NPA,
As far as you're concerned, loan is, the land is mortgaged.
yes, my lord. Entire land is mortgaged. Then they gave a request letter stating that two unsold flats are there, you attach that, this one, you leave about the land. Then we said we can't, because the entire land is mortgaged, we have to go ahead with the land only, because the flat is not mortgaged. So after that, they entered into sale agreement with that unsold 2 flats with the respondent number 2 and 3. And they have made the payment to the respondent 2 and 3. That payment has been made to the loan account. It is not direct payment from the agreement holder, my lord.
My lord, senior counsel will come, my lord, please. You wanted to file.
He has an interim order in this.
There is the interim order, and the interim order,
Yes, my lord.
this court has directed them to deposit 50% of the outstanding amount. They have not deposited.
The interim order granted.
Interim order was passed on 23/9/2024, my lord.
He complied with the interim order.
No, my lord.
In favor of us.
30 only 30 lakhs.
Interim order was given in favor of us, my lord.
No, in your favor only, you have to comply with the order. Interim order on the condition of depositing 50%.
They have deposited only 30 lakhs, my lord. The outstanding was 1,39 lakhs.
Like in this matter, my lord, I am appearing for respondent number 2, my lord. My lord has on the last date, previous occasion expressed what right the agreement holder is having, my lord.
This is smart. Anyway, he wants to have audience.
One
Now, the senior
submission.
counsel is coming. This is
My lord,
matter
kindly.
on.
After vacation.
No, my lord expressed the opinion to dismiss because agreement holder is not having any right to challenge the.
Expressing the opinion, I have to dictate the
No.
order.
May I make only one submission? My lord, I have also produced the document to show that whatever the amount paid by the respondent number 2, I have already returned. Last occasion, they made the submission that they have not received the
I
amount.
know, one final opportunity to them.
Please.
What
They
is
have
that?
filed 2 original suit before the civil court and obtained stay order, my lord.
This is matter on 23rd. On the
23rd,
day-
I may not be here, my lord. Any other date
I'll post after vacation.
after
This
vacation.
is matter after vacation, interim order earlier granted, is extended till then. Yes.
I'm sorry. Before vacation, any date may kindly. 24th or 25th.
There is no.
25, don't worry.
Before vacation on date may kindly be given, please. Because my lord has heard.
This is a matter on 25th.
My lord, senior counsel is not there, my lord, 25th, please, my lord.
You have no choice. Engage some other senior counsel.
Please.
Yes.
I'm great.
This matter, lords may kindly grant me a week's time, my lords, to complete the instructions.
Petitioner, my lord.
Direction seeking registration of an FIR, my lords. The BDA has taken some action, my lords. Lords may kindly grant me a week's time to secure complete my
This is matter.
My lord,
after
the
vacation.
same, my lord, the same may be taken on record, my lord.
Huh?
Whatever
It is
the submissions
submitted
are.
by the land council appearing to the BDA that the BDA has taken action and he would play.
That is only oral instruction, not.
As per his instructions, BDA has taken some action in this regard.
So place it on.
With regard to the same, with regard to the issue in dispute. And he would place all the material on record. This is matter after vacation. Yes, next.
Please, my lord.
Appear for the petitioner. My lord, this matter, the petitioner an agriculturist. In 2016, the petitioner had taken 3 loans amounting to about 12.6 crores, my lord. Because this was under the BESCOM scheme for providing solar rooftop project. Thereafter, once the rates were reduced by BESCOM from 9.5 to 3.2, certain repayments were delayed and.
That's the letter dated.
Yes, ma'am.
24.
So, my lord, as against 12.6.
By the respondent bank withdrawing the OTS sanction dated issued in favor of the petition. Now,
on the last
as per this sanction letter
Yes,
dated 29/20/24, what are the terms of it?
Yes, ma'am. It's a page 93.
Page?
93, ma'am. Annexure G.
Yes.
Lord, the one is accept one. I'm reading one, my lord. Accept rupees 12.75 crore. So that was the OTS amount, my lord. But by which time already 8 crore is already paid.
Next,
So in addition to that, yes.
Rupees 2
So
crores.
first is 2 crore, which would be kept as a lien, my lord. Thereafter, 10.75 crore to be paid. That is the second.
Hmm.
Now, my lord, that is a balance. It says balance. Now the second installment is 1.50 crore, my lord.
Yes, second installment.
Then comes 2 crores. Then comes
Third
3
installment.
crore.
Finally, the entire
Finally,
transaction
the
shall be complete
4.25
when?
crores. Yes. So finally, 12.75 was
When it should be, when the entire OTS will be complete?
within 90 days.
90
3
days.
months. 3
That
months.
is 90 days from when?
From the first payment.
First payment is when?
Well, the first payment was 2 crore paid as
Correct
upfront.
date.
From the date of this letterman, 29, 24.
So,
2024. From the
29, 2024. So it would, 90 days would complete on?
20th of 12th, my lord, December.
2012. Now, where is that now, present letter?
Present?
Impugned letter.
And then
No, that is the impugned letter is the annexure J at 99.
Let's read that.
Yes.
Yes.
Except 12 point, I'm reading one from bottom one. 12.75 crore. That's the same. They have extracted the same thing. First installment, second installment. Ashma, kindly see the next page 100. Again, same
However,
extraction.
you have not honored the OTS sanction as
Yes,
per the
that's all.
sanction
That's all the
term.
finding is. But
Hence,
I've
competent authority has been withdrawn.
Yes.
So and so.
So I've
This
paid
letter
5
is-
point
No, no, this
admittedly.
letter is dated 24 to 2025.
25. Yes.
So as per the OTS, you are supposed to complete this whole exercise by 29, 2024.
12. 2012.
2012, 2024.
Yes.
So as you have not done, they have issued a letter on
Yes,
24 to
yes.
2025.
So I'm before this honorable court challenging this letter. My lord, the grievance is only this. My lord, now as against a loan of 12.6 crores, I've paid as on date 24 crores. I've paid 24 crores.
When did you obtain the loan?
In 2016. 16.
How
Now,
much? What was the amount of?
12.6 crores, my lord. 12.6 crores. Now, under the OTS, I have paid 5.4 crores. Now, my lord, now as per their schedule, within 90 days, I have to pay the OTS amount of 12.75. OTS was fixed for 12.75. Now, within 90 days, I couldn't mobilize that money. I paid 5.4 crores. Now, while requesting for the OTS also, my only request to them was, my lord, there were about 5 to 6 properties mortgaged with the bank. There is one commercial property. So my request to them was that instead of releasing all the other properties stepwise, you please release my commercial property first. Then I can monetize that property. Now, being an agriculturist, that is the only way I can monetize and pay. And it is not that it's a fly-by-night operator. I'm a very well-known person in that village, an agriculturist. I have mortgaged all my properties with the bank. And this property, now my lord, subsequently what has happened is when this matter came before my lords had actually directed me to give a fresh representation. Representation was given and they have issued another email, which was actually produced by my friend on the last occasion. Lord, you may kindly see that email. It's produced before my lords. In that, my lord, to my request that you please release the commercial property first, because I have already paid 5.4 crores. Please release the commercial property instead of agriculture property. So there in the letter, in their email, what they say is, further for release of the commercial property, the borrower shall be required to deposit an amount equivalent to the market value of the property. The said amount will be maintained in no lien bank account. Now, Lordship, may kindly take once again page 93, my lord. I just wanted to show the property. That market value of the property is 1 crore 29 lakhs. In fact, the property that they would have released otherwise is an agricultural property which is 5 crores market value. I am saying I've paid 5.4. Don't release the agricultural property, which is 5.4 is the market value. You release the commercial property, which is only 1.29 crores, because for me, monetizing commercial property is easy. I'm not trying to run away from my liability. I want to pay. There is no way that I want to be called as a defaulter. All I'm saying is that, and my lord, it seems in March, last month, my lord, there were about 3 sittings before the Adalat. So they also said the same thing, that you pay 1.29 crores and we will release the commercial property. My request was that if that be so, I will pay. But at least you reduce that 1.29, make it some 75 lakhs or 80 lakhs. Release that commercial property.
Yes.
But the annexure J, which is assailed before this honorable court at page number 99, it is not in dispute, my lord. The one-time settlement offer which I given and certain, my lord, benefit.
Failed to honor that.
My lord, it is not in dispute. They are not honored. And my lord, in fact, my lord, bank given, my lord, some more time. In fact, my lord, my friend only made a submission before this honorable court. In the month of December, they ought to have been paid. In fact, my lord, I issued this letter in the month of February. Therefore, my lord, my bona fide cannot be, my lord. They would have come before the bank and they would have, it is not. My lord, in this context, my lord, my friend is making submission saying that I given one more request. That is certainly not before this honorable court now. In this, my lord, in respect of, my lord, the time which I given in the one-time settlement offer dated, my lord, in page number 90, page number 93, 20th 9 2024, which is not complied. And my lord, the extension or my lord, any other, my lord, beyond the, my lord, scope of the, my lord, one-time settlement offer. My lord, this honorable court, my lord, in the Supreme Court, in the case of, my lord, I'll just point out one judgment in the case of State Bank of India versus Arvind, squarely applicable to this case. Once, my lord, they are not complied the one-time settlement offer or my lord, offer given by the bank, my lord, paragraph number 3.1 to 3.4.
Yes.
In the case of, my lord, State Bank of India versus, my lord, Arvind Electronics. Paragraph number 3.1, page number 5. Sri Kapul unconscionable appearing on behalf of the bank, relying upon the decisions of this honorable court in the case of the Bijnur Cooperative so and so, has submitted that as observed and held by this court, the grant of benefit under OTS scheme cannot be claimed as a matter of right and shall always be subject of fulfilling the eligibility criteria mentioned in the scheme. It is submitted that in the present case, the borrower is required to fulfill the terms of the conditions of OTS and was required to make the payment as per the schedule mentioned in the sanction letter OTS. It is submitted that any deviation from making the payment as per the sanctioned OTS scheme would render OTS sanction infectious. As per the sanction letter dated 21/11/2017, it is submitted that therefore the High Court in excess of power under 226 of the Constitution ought not to have granted any further time dehors a sanction scheme and or sanction letter dated 21/11/2017. And that too in excess of powers under 226 of the Constitution on the Constitution of India. Then, my lord, I'll point out, my lord, paragraph 6.6. Lord, it's a contention, my lord. 6.6 onwards, my lord.
Yes.
Page number 17. It is requested to be noted that under OTS scheme, which was originally sanctioned in the year of 2017, the borrower was required to pay sum of rupees so and so against the outstanding of rupees so and so. Therefore, under the original sanctioned OTS scheme, the borrower was getting the substantial relief of approximately 3 crore. The bank agreed and accepted the OTS offer on the terms and conditions mentioned in the letter dated 21/11/2017. In the sanction letter dated 21/11/2017, it was specifically mentioned in clause 4 that the entire payment under the OTS scheme was to be made by 21/5/2018. Otherwise, OTS would be rendered infectious. Therefore, the borrower are bound to make the payment as per the sanctioned OTS scheme. Therefore, the High Court ought not to have granted further extension dehors the sanctioned OTS scheme while exercising the power under Article 226 of the Constitution of India. The submission on behalf of the borrower that in the case in the some other borrowers that time extended the concern, the same is neither here nor there. The bank mutually can agree to extend.
Yes.
Therefore, my lord, the petitioner, it cannot be a matter of right. At the most, my lord, he can give a my lord fresh proposal, which my lord with all my lord fairness will consider. Therefore, my lord, the present petition will not serve for consideration in respect of OTS which is granted with certain conditions which is not complied by them. They can't, my lord. Therefore, writ petition will not serve for consideration.
Already we have approached them. In the Adalat also they have.
No, that's true.
No, and the letter.
The writ petition is filed questioning the letter. There is nothing wrong with the letter because you have not honored, they have cancelled.
Yes, I'm
Once it is not there, what is left for you to sue?
No, just one submission.
Any further prayer?
Because, my lord, now here it's.
That's between you and the bank.
Yes,
nobody can compel them to do it.
Now, my lord, the email of the bank, the last email of the bank, which was produced by my friend is before my lords. Watch me kindly peruse that. It is on 25/3/2026. It was produced before my lords. So there they say.
But all, if they've given you a mail, you have asked them something. That's it between both of you. There can't be an order
so let them at least
judicial order on that.
Yes, my friend is also here. my lord, as I said, my lord, I do not wish to escape from my liability. I want to pay, I don't want to be a defaulter.
Even if that property is released, what is the amount? The market value is 1 crore according to you.
No, my lord, I can always mortgage, I can monetize it, my lord. See, because 1 crore is on at that point of time.
How can you pay me remaining 10 crores?
Yes, my lord, we have made
14
arrangements, my lord. We have made arrangements, it will be done, my lord. So let them put me on condition, let me put me on terms, I have no problem. And my lord, the problem is that, my lord, whenever there's a discussion in the Adalat also.
Generally, why will the bank release on a piecemeal basis for secured assets?
No, but Lakshmi, kindly see, that is the condition of OTS. I pay first installment, they will release one property. I pay the second installment, they release the next property. So that is part of the
Provided
OTS.
the OTS scheme is, it works out.
No, so, my lord, my only submission is this, that now in the Adalat also.
You give a representation, it's for them to consider. I'll say let them consider if it is convenient to the bank.
Because in the last mail, just one submission. I understand the limitation of this petition as well as my submission limitation also I understand. Just one submission. Now, in the last email, what they say is that you pay the market value of the commercial property and we'll release it. That is 1.29. My lord, if worst case scenario, if I have to pay that for them to release it, at least let them issue a sanction letter. Because what happens is, if I pay 1.29,
it will all happen. What you have to understand is it will all happen if the OTS is in force. No, OTS is not in force. If it is not there, no, if this court says that letter is bad and I set aside it, then only I'll be able to pass all these directions.
No, then as my friend suggested, I will give another letter with respect to this specific
That's
issue.
for them to consider in
And
accordance with
let the
law, as
matter
per
be
their
kept
banking
pending so
policy.
that we can come back to the court and report, my lord, because it acts as a protection
the
for
same
me.
submission will be repeated. In fact, my lord, we assisted this honorable at least 2 or 3 occasions in a very same issue.
No, let
But
this,
there is no.
I'll say, let the bank consider it in accordance with law within a period of 1 week from the date of receiving your representation.
That can be, and let it be before this court. Let me come
Why?
to this court. My lord,
And when the time frame is fixed, why should it be before the
no,
court?
it is not for the time frame, because, my lord, based on the consideration, my lord, if I have some protection before this court, that's all. Because he's an agriculturist, my lord. All he wants to pay.
But
He
it's
wants to
something
pay.
you're seeking beyond the scope of the jurisdiction of the court.
No, my lord, I'll just point out one thing.
My lord, let only this process be
these-
before the court, and the next occasion it can be disposed of, my lord. Let this process be before the
I'll not pass any order then. You give it to them, let them do whatever it is, next week, whatever outcome, basing on that, I'll pass.
So, Lordship may give them more time, 2 weeks, 4 weeks also, it's okay.
No, 1 week.
I think by this time, I think already put the property for auction also, my lord, I have to take instruction. The scope, my lord, very limited
No, it
points
is
for
not come for
consideration
auction
before
yet.
this honorable court. Whether, my lord, I should extend the time. That, my lord, in fact, in view of the honorable Supreme Court, my lord, the writ petition will not survive for consideration. If they will, my lord, give any, it is up to me, my lord.
And
I'll
Lordship may
consider.
permit me to give the representation and I will take my chances.
Yes.
Then
The present petition is filed, seeking the following prayer. Then counsel to the petitioner submits that the petition, in fact, as per the OTS letter dated 29/2024, has already paid an amount of rupees 5 crores.
5 crores 40 lakhs.
5 crores 40 lakhs. As he could not mobilize the remaining amount, he could not pay the same. It is submitted with the land council that as per the OTS, as per the letter dated 29/2024, if he pays on a phased manner, basing on the payments, the properties which are mortgaged will be released. It is submitted that as there is a commercial property, according to them, the market value of the property is 1 crore and
29 lakhs.
1 crore and 29 lakhs, as he has already paid 5 crores 40 lakhs. The said property, maybe if the said property is released, he would be in a position to sell the property and pay the entire outstanding amount. It is submitted that in the Adalat and also in the Adalat and the negotiations were done, but the bank is not coming forward with the same. Hence, there may be a direction to the bank. Next part. Then counsel appearing for the respondent bank submits that when the petitioner has failed to honor the OTS letter dated 29/2024, as per that, he has to pay the entire amount by 2012/2024. The bank, in fact, has waited till the
February
February
24th February 2025 issued a letter.
24th February 2025, and thereafter they have cancelled the proposal earlier given to the petitioner. It is
Return the
submitted.
OTS.
It is submitted that the bank has accommodated the petitioner, and now, and the petitioner has questioned said cancellation letter. It is submitted that this court, this court cannot interfere, may not pass the order directing as sought for by the petitioner in the light of the law laid down by the apex court in State Bank of India versus Arvindra Electronics Private Limited, arising out of civil appeal number 6954 of 2023. Land Council has relied on paragraph number 3.1 and
Below 3.12, 3.4, 6.67, 7.1.
and
6.67 and 7.1. 6, my lord.
And
7, 7.1.
7.1. In the light of the extract that. In the light of the same, it is submitted that there cannot be any order from the court exercising the jurisdiction under 226. Next paragraph. And the writ petition has to be dismissed. Having heard the counsels on either side, there is a material non-record. The undisputed facts of this case are that the court at the bank has given a one-time settlement offer on 29/20/24, and the petitioner has to comply with the same by 2012/2024. Admittedly, the petitioner has not honored the said letter. Only a part payment of 5 crore 40 lakhs was paid. Then after waiting for 2 months, the bank has cancelled the scheme, cancelled the offer in the month of February. This court do not find any reasons to interfere with the same because the bank has given an offer accepted by the petitioner and the same was not honored. And then the bank is always at liberty to cancel the same. This court cannot find fault with the same. Further, in the light of the law laid down in State Bank of India, referred to Supra, this court cannot extend the time as the same is granted by the bank as per their own commercial terms, which are viable to the parties. Next para, and the same para. The next submission is that there may be a direction to the bank to release the said property. The petitioner is entitled for release of the properties provided he on a phased manner he pays the amount and honors the OTS. When the court is not finding fault with the letter, this court cannot grant any positive direction to the bank. However, the petitioner is always at liberty to give a representation to the bank, and the bank can consider the same in accordance with law within 1 week from the date of receipt of the representation.
Let them give a representation, my lord, immediately.
Whenever it is, I said, whenever it is, consider it. Accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner. This court is not inclined to interfere with the order impu. However, liberty is given to the petitioner to give a representation to the respondents. And within 1 week from the date of receipt of the representation, the same shall be considered by the respondents in accordance, respondent bank in accordance with law. Accordingly, the petition is disposed of.
Grateful. For the petitioner.
Yes.
Your lordship has clearly said NBFCs not state within the meaning of Article 12, therefore writ petition not maintainable. I have one thought process, my lord, if I may place it before your lordship. In this case, there are 3 loans. 2 are regular loans from the bank, the NFC. The third one is a mudra loan. A mudra loan is a social action taken by the central government for MSMEs, saying that mudra loans are given without any security. The bank, the NBFC or whoever is dispersing it, acts merely as a dispersing agent of the central government. To that extent, my lord, the writ petition may be maintainable. I'm just, because there is a judgment which says that Article 12 is not a...
No, here you have initiated the proceedings that are initiated under the Surface Act by a private financial company are assigned before the court. Now, you have a remedy before the DRT that it is not maintainable. Even assuming that it is maintainable, why can't these issues be agitated before the DRT,
I'll
but
make-
not before this court?
I'll make submission, very honest submission here. My lord, if I go before the DR, now what's happened is, this Mudra loan was given. They have included the Mudra loan in the SURFACE Act. It is completely outside the scope of the SURFACE Act. The Mudra, to that extent, my lord, the bank cannot say that the Mudra loan. Now, if I go to the DRT, I'm going, saying that there is something wrong committed under the SURFACE Act. Therefore, please rectify it. Now, for example, section 13(3)(a), they have not replied. All that will have to go there. But where a property which does not come within the scope of the enactment, they purport to exercise jurisdiction. My lord, my efficacious remedies before your lordship. My lord, today, what happened now if only this portion, if I'm going to the DRT? They will say, oh, now this is a common notice, single notice which is issued. So I have to deposit 75% of all that they claim. The other point is, now all this is being done, they say I'm an NPA, but till yesterday, EMIs are being received from me. This man is not a very rich person. EMIs are being received by him, by the bank. All that I'm saying is if the bank removes the tag of NPA, well, I would really be satisfied because I don't want to go with the tag of
Now, you accept the Hinduja Leyland Finance Limited. Nobody else is a party to this petition.
No.
Neither the central government nor anybody.
No, nobody
So
else
this is
won.
completely a petition that is arising out of the surface proceedings. Now, the difficulty is I can't take, I have already disposed of several matters. There can't be any exception
My
to
lord,
this
the
case.
point is, my lord, the other petitions, I don't know. My lord, here a Mudra loan is involved.
Now, the
Now,
question is
they are only
that-
acting as an agent of the central government.
No, the point is, if can this aspect be considered by the DRT or not? It can be considered because you are assigning the steps that are taken by the bank, so and so.
My lord,
Whatever is the
my lord, I
irregularity-
agree. If they have taken steps under the SURFACE Act, the appeal is provided under the.
But they have taken those. No, in respect of that loan, which they wouldn't have taken under the surface, they have taken.
Therefore, it is not an action under the SURFACE Act. is what I'm
No, but they have taken that step. The DRT can say that it is wrong, don't do it.
May I make one submission because this is, I'm not really on the question of the liability. All I'm saying is if the bank could consider removing that NPA tag, I'm continuing to pay EMI. I will repay all the loans. I'm not asking for any favors. I'm not asking for any concessions. Not asking for concessions.
No, but ultimately it boils down to the same point that the court is entertaining.
Or may I make one request, Mother? Could your lordship adjourn it by about a couple of weeks? I'll speak to the bank and say, listen, why don't we try and work out something? This is not a case where I'm coming here to say, no, I'm not due this money, I'm not due that money. No.
Please come. The writ petition is filed against Hinduja Leyland Finance Limited in the light of the law laid down in so and so. The writ petition is not maintainable against the private finance company. Then a senior counsel appearing for the petitioner submits that the Mudra loan, which is granted by the central government, cannot be part of the surface proceedings. Even in that case also, when the writ petition is not maintainable before this court, the petitioner has to go before the DRT and the DRT can consider all these issues. It is submitted that the petitioner required some time. List this matter on 10th of June as part heard.
Grateful.
For petitioner, my lord. Senior some inconvenience, my lord. Kindly request date may be fixed, my lord.
Why?
Senior inconvenience, my lord.
No. When the matter is there under the caption dismissal, I will not grant any time.
Can you request pass over,
You
my lord?
can't, yes, pass over, ask the senior to come.
Connected matter
We
is
don't
withdrawn.
allow advocates to take the course so lightly. Yes, 20. Give it. The,
Serial number 20.
uh,
Matter is closed, my lord. Account has been closed.
when,
Last week, that message has come.
Learned counsel, there is, as there is no representation on behalf of the petitioner. The matter was directed to be listed in the caption dismissal. Today also, there is no representation on behalf of the petitioner. Learned counsel appearing on behalf of the respondent, bank submits that the account is closed.
They're paying
Hence
16,000
nothing-
rupees.
Hence
OTS.
nothing survives the consideration. in this writ petition. Accordingly, dismissed as instructions. Yes, next. Yes.
My lord, in this petition, my lord, I have sought certain prayers with regard to the grievances that the petitioner had against respondent number 3 and 4, the inspectors. He was a jeweler by profession. But I'll only make one submission, my lord.
One
They
minute. Let me
represent-
look at the prayer.
Please, my lord. I am not stressing on the other prayers B, C, D, my lord. Only A.
To writ of mandamus
Please,
to
Now,
consider the
Please,
representation.
even on that, I'll also mention to lordship.
No, A, are you pressing?
Only A, my lord. And A was given in the year 2022. So I'll only request lordship that I'll give a fresh representation addressing my grievance. They will
What is the representation?
my lord, he was a jeweler by profession. He was a jeweler and he was owner of a jewelry shop. The respondent number 3 and 4 were the inspectors of particular police stations.
No, this representation is seeking, what is the relief you are seeking in that?
The gold were illegally taken from the shop without even issuing a notice, and no notice and no proceedings of the court is given to him. They have only come.
If they are not taking this complaint from 2020, you are just keeping quiet. You could have filed a private complaint.
The issue is this, my lord. Now he has been going to the police station multiple times. They are only telling him that there are certain proceedings pending in the court, but no information is given to me. I'll file a refreshed representation.
Has given representation to Honorable President, my lord.
Everyone he has given. President, Prime Minister
of India, my lord.
No, what are you doing? What are you doing
Seeking-
from
My lord,
28/5/2022?
Lord is not given, he has to file, if he is agreed, my lord, he has to give a complaint under section 20D before the competent authority, my lord.
First of all, what did you do from 28/5/2022? What happened to that complaint is with regard to the what is that, the gold taken from his shop?
No, my lord, that
And
are
where
all-
is it,
Sir,
where
that
did
are
you
all the
produce?
subject matter of the proceedings, my lord, because the
Which
petitioner
proceedings?
in several crimes were registered, my lord.
You have to tell him,
I will-
at
I will
least you
sub-
should have filed your objections
I
to
will file, my
the,
lord. I will-
so then why should you keep him in dark?
Please, my lord. I will
Let's this
file objections,
matter, let's this matter on 28th, by the time Learned HCGP shall place before the court, what are the proceedings pending against the petitioner in which court?
Please.
Yes. There is no representation on 26/3/2026, 15/4/2026, 17/4/2026. In spite of giving reasonable opportunity to the petitioner by posting this matter for dismissal, still the petitioner, there is no representation on behalf of the petitioner. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Case 24.
The DRT has dismissed the essay on limitation ground, as your lordship has been passed the order in view of the Supreme Court, one aspect. Second aspect, they have the opportunity to prefer the appeal against the order, essay. Third, they have not complied the interim order.
No, they preferred an appeal.
No.
According to you, they should have availed the alternative remedy.
Yes, alternative remedy, efficacious remedy is available.
When is the interim order?
Interim order, your lordship kindly see. Even single 1 rupee has not paid.
When is the interim order granted?
I will.
Interim order is granted on 3/3/2023. Have you complied with the interim order?
Yes, my lords. I have paid 1,65 lakhs to the bank.
No.
The fact is,
Where is the acknowledgement to show that?
the receipt is also provided to them only. It was deposited directly to the account.
How can there be such a statement that you paid and he says he has not paid?
I can furnish that document, my lords, but the facts remains is, I am the successful auction purchaser. I purchased this through e-bid. Sale certificate was issued in my favor. That document is produced before this court at Annexure D. This happened in 2016. Immediately after that, the original landowner, he preferred a writ petition before this court and he obtained a stay order and possession was not handed over to me from 2016 to 2019. In 2019, the writ petition came to be disposed of. It was only subsequently possession was handed over to me and I started paying EMIs. In the meantime, for the delay of 2016 to 19, they initiated proceedings against me before the DRT. They obtained an order and that came to be came to my knowledge only in the year 2022 that was challenged before the SCA.
You are not,
They
you are
rejected
not a
it.
party.
I was not a party. No notice was issued to me, and I had also intimated the bank about my change of address way back in the year 2017 itself. The document was also produced before the bank, stating that I am not residing in this address as of now. Henceforth, for all communication, you can communicate to me. But they have sent it to the earlier address only. So I was not informed. So it was because of that reason there was a delay in filing that SCA, and because of that limitation point, the SCA came to be dismissed, and I preferred a writ petition before this court. Even now, my lords, during the pendency of this petition also, I had approached the bank. So the matter was referred to Legal Service Authority, and a joint memo came to be filed by me and the bank, stating that the entire amount is to be settled for 5 crores 65 lakhs. Out of that, 60 lakhs is to be paid. 60 lakhs to be paid on or before 39, that I have paid. 10/10/2025, 80 lakhs is to be paid, that I have paid. Balance amount of rupees 4 crore 25 lakhs to be paid on or before 2011-2025 was the award that was passed before the Legal Service Authority. Out of this amount, I could not arrange some amount, and 25 lakhs was paid, and I requested the bank for fresh OTS.
Okay.
For this, no, my lords, the bank manager himself
No,
came
having
out with
a
a proposal.
Lok Adalat award, when there is an award, you say that part of it I will comply.
It's already complied, and for 4 crores, we sought for extension of time. For that, they sent it for the head office. That is still pending for consideration. They said we are likely to get an approval from the head office, maybe in another 1 week or so.
So what instruction they are giving? What is that you are getting? The bank is not giving him that instruction.
I will make one submission, madam. He might be approached the court later stage for OTS. OTS has failed. He has not complied also. That is not his opening mouth for that purpose. And earlier he approached the civil court and obtained the order. And I cannot enforce the order till date. Your Lordship, kindly see my objection statement. OA has been decreed in the year 29/2/2020. I have not received an amount. One or the other reason. And another point, even courtesy sake, they have not served the copy to the respondent bank. I voluntarily approached this honorable court by way of filing this petition, objection and everything, my lord. And they have not complied the interim order. Yes, I clearly stated in my objection statement. My lord, kindly see.
Have you seen the objection statement?
Yes, my lord.
Yeah,
They
yes,
have
sir.
only said they have stated that they have not received. But my instruction is that he has paid 1 crore 65 lakhs to the bank.
No, simple. Whether the interim order is complied with or not is the question.
No.
That I have to
When they
verify the
filed-
records,
when they filed-
because I filed my
Not paid,
NOC
not paid.
wakalat, it was very recently
They
I
have stated
filed.
so in the objection. You should have given you should have filed a
Yes.
rejoinder to that.
No, that's exactly, my lord. So I requested my client regarding that. I asked him to furnish the details as to when it was paid.
Your client keep on changing the advocates, and whenever the matter comes, and on that ground, we will not start everything afresh.
No,
It will start from that day.
My lord, kindly see my para
I have to
6
look
of-
into the records
para-
also once
1 minute.
before.
Para 6 of my objection statement. It is submitted at, sorry, that is a home loan. And there is no question of, he has taken an auction purchaser, he is successful bidder and has received the position, and also he has taken enjoyment, and after surface action, he has not replied and he has not taken this.
So this matter as part heard on 25th. Whatever you want to file, place on record, you place.
Yes,
That
ma'am.
day I'll discuss this matter of.
Yes, ma'am.
next.
And my lord, kindly see, since from they change the council, it's okay. Thereafter 4 days are going on day by day. Your lordship, kindly see.
You can't say that.
No, no,
There are-
that is my
there are
prayer.
matters-
No, no,
They're
not
going on for years together. Surface matters are pending.
no,
before the
without
court.
single NP. How the bank survive?
But the bank is surviving. Yes, next.
Surviving. If 10 members like this, it's a very difficult matter.
Yes, next.
25, my lord, I may be permitted to withdraw.
Take
As
the
infractions.
memo is for seeking to withdraw the writ petition.
Go ahead.
As the petition has become infructuous, accordingly memo is taken on record and this petition is dismissed as withdrawn. Is 26.
In this matter, my lord, endorsement is issued, my lord.
Give the file. Take it from him. The present writ petition is filed seeking the following prayer. They're seeking police protection.
Yes, madam.
That
It
is
is a money. Yes,
1
madam.
and 2 are about the police protection.
Yes, madam.
Any order, court order, anything?
Nothing.
Then 3, they're seeking an order to take appropriate action on the complaint. What
is a
happened to the complaint?
Acting on the complaint, my lord, it is a money transaction. Statements were recorded, endorsement was issued, my lord, to approach.
Civil in nature.
Yes, my lord.
Seeking the following prayers. There is no representation on behalf of the petitioner on 16/4/2026. Hence, the matter was directly listed under the caption for dismissal today. Today also there is no representation, and counsel for the HCGP submits that they cannot grant police protection. As per the circular, what is that circular?
2018, I will provide, my lord, I will.
As per the
2008.
circular issued by the DG, the Director General of Police
Yes, ma'am.
in the year 2018.
18.
It is submitted that as far as the third prayer is concerned, as the dispute is civil in nature, they have already issued an endorsement in that regard on
30/8/2023.
13/8/2023.
13/8/2023. Please.
2023, considering the fact that the respondent police have already informed the petitioner that they cannot entertain the complaint as the same is civil in nature, and the other 2 reliefs cannot be granted by the respondent. The protection cannot be granted by the respondents. Accordingly, the writ petition is recording the submissions that the submission of the HCGP, that petition is disposed of. What about this?
My lords, I appear for the petitioner, my lords. My lords, I'm seeking for a writ of certiorari to be issued to quash the impugned communication at annexure A, my lords. My lords may find it at page number 16.
What is that communication?
My lords, this communication is basically directing the police to not dispose of any property of the petitioner. The petitioner, at the time of filing, he was extremely ill and he needed some funds to be.
Who has issued the proceedings?
My lords, this has been issued by DGP, that is respondent number 2.
Saying that?
Stating that no property may be disposed of. This is in connection with
Not to
crime.
register any property in relation to the pertaining to this crime number, my lord. That is the communication between the CID office and the registrar,
lords,
sub-registrar. Because the said properties are the subject matter of the investigation, my lord. Therefore, my lord, there was a communication.
Not to register.
Not to register any properties
How
standing
can
in the
he
name
give
of the accused persons,
No,
my
no,
lord.
how can he give such a communication?
Because on that transaction, my lord, they purchased the property, my
No,
lord.
no. What, under which authority?
Just to, my lord, protect the interest of the.
No, he can't do it. It should be a judicial order.
But the question
Somebody
is, my
should do
lord,
it.
there is.
The court should do it. The court should do it,
Yes,
not the
ma'am.
DGP.
That was, my lord, on last occasion, my lord, kindly see the order sheet, my lord.
Hmm.
This court directed whether the permission is obtained,
Hmm.
whether the magistrate permission was obtained, my lord.
It's
before-
obtained.
Yes, it is obtained. I filed along with memo, my lord. On 18th June.
So where is the permission of magistrate? Magistrate herself will pass an order.
Yes,
It is not that he is not a messenger between the court, between the registrar and the court,
Yes, ma'am.
DGP.
Yes, ma'am.
It's for the court. If the court feels that the property shouldn't be registered, it will pass an order directing the registrar. DGP has no business to.
It is a communication, my lord. It is a
It
communication.
can't be, can't be. Get instructions, file your objections on that.
Please.
It is submitted that.
My lords, I may make one more submission. This crime number 2275 and other connected matters, these were adjudicated and we were discharged of the offence. The petitioner has been discharged of the offence. Further, it was revised under the sessions judge, and further, the same proceedings were appealed in the High Court, my lords. These proceedings have been stayed. At the moment, there is no crime that is operating.
That's the part. The DGP cannot do this.
Please.
On that ground, we will set aside.
Please.
The petitioner submits that the DGP has issued a communication to the registration department,
Sub-registrar.
to the sub-registrar, not to register the document pertaining to the properties pertaining to the petitioner in respect of a crime which is pending. Land counsel of the petitioner submits that. The DGP has no such power. Then HCGP submits that on the last occasion. The court has directed him to find out any
Permission is obtained.
permission is obtained from the magistrate. The petition, the HCGP shall place the instructions before this court under which provision of law the DGP is permitted to communicate to the registrar in this manner, even if the court permits, if that has to be communicated by the court or by the DGP. Yes. This is matter when?
After vacation.
This is matter after vacation as parted. Yes, 28.
For the respondent, Bank Lordship. Memo for withdrawal had been filed by the petitioner because it becomes infructuous. There is no sale has taken place.
The memo is filed seeking to withdraw the petition as the petition has become infructuous, accordingly dismissed as withdrawn.
Memo is filed by petitioner.
Petitioner only. You can't file a memo to
No, no,
withdraw
there is
his writ petition. Yes, any signatures? All reserved matters pending, update the list. Because they have become more. Huh?
ಮೇಡಮ್ ಇದೆಯಾ
ಮೇಡಮ್
ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಮೇಡಮ್ ಇದೆ ಆಫ್ಟರ್ನೂನ್
ಲಿಸ್ಟ್ 2 ಯಾವಾಗ ತಗೊಳ್ಳೋದು ಮೇಡಮ್